Any mentioning?
I'm allowed to mention one matter, which was based upon the letter pending before the Honorable Apex Court as regards economic jurisdiction. The stay order is going to expire this month, and there will be no circuit thereafter. So I'm mentioning this year. Other parties not appearing. Yes, sir. For Mr. Jaipal, in this case, nobody is appearing.
When was the order passed?
The order passed for 6 months stay was granted, which is going to be expiring this month.
But you have to come with a notice, Mr. Khan.
Other parties
So
appeared.
On the last day, nobody appeared.
Nobody appeared. When stay order was passed, nobody appeared.
To be mentioned at the when it is expiring.
It's expiring in this month.
You ascertain if anybody has been engaged, then give a notice. It will be there day after tomorrow.
Another matter is serial number 5, first appeal is there. Along with there was another appeal, which is
serial number?
FAT number 2 of 2024. I think serial number 5.
No, 6. 2 7. Yes.
Another appeal was there along with this. So I informed Mr. Jaipal, I will mention this matter. Arising out of the same judgment. One appeal is listing, another is not listing. So that's why I'm mentioning this. So that it may also come in the list tomorrow.
Huh?
There was suit and counter claim. If I put 2 appeals.
No, এটা তো item number 7 বলছে। এটা তো FMAT.
FMAT, it is also FMAT.
So remind us when we take up the matter.
Yes.
Let me allow to mention one matter, Doctor. There's a one WPA has been filed. One WPA has been filed against Blair that challenged the order in MAD 71 and 72. And the last circuit, WPA has appeared, and in that WPA we have direction to file the affidavit. Where in MAD, we still have the time to the opposite party to complete.
What do you want?
Release the matter on tomorrow.
Who is your other side?
Aru Prasad sir is appearing.
Give a notice and mention tomorrow.
Yeah.
Give a notice that you would mention and then mention.
Yes, the copy.
Pardon?
I'll serve the copy.
Do whatever you have to must give a notice. Then we can proceed.
Yeah, okay.
Yes, call the man.
Item number on.
I'm appearing, my lord.
Can 3.
My lord, I am appearing for the petitioner in Can 3. In Can 3, I have prayed for extension of time to deposit the awarded amount. This honorable court has granted.
Given copy to Mr.
I have given. Since it is a financial year end, my lord, I seek till July.
So my lord's attention to the order passed on 11th March 2025.
Why didn't you tell the court at that time? You could have told the court that we don't have fund. We are begging for more time. You should have said that to the court.
My lord, after I intimated the department came up, informed me that fund is not there.
Yes, what do you say, Mr. Das?
I will draw my lord's attention to para 4, 5, 6, 7 of the order.
But Mr. Shivalan, we cannot give you till July. There has to be a reasonable extension. This way it cannot go on.
July 1 fund will be received, my lord.
Then you will execute the award. What can be done?
My lord, I request that.
Your statement is that it may come anytime within April to July. So keep it in July.
My lord.
Your abandonment in the application
Yes, my lord.
is
As an abundant precaution, I have said, my lord. If it is coming before that, we will deposit, my lord. Even if it is coming before that, we shall deposit.
abundant caution, it won't be you tell us that by which time you will pay, we will fix that.
Well, the para six.
3 months, my lord. Within 3 months.
Order para six.
3 months cannot be given,
Para
sir.
six में kind issue.
Sir, let him complete, we shall. You show us what you have stated in your CAN application.
My lord. In this awarded amount is 39 lakhs 28,020 only, my lord. Out of that we have
Pardon?
out of that we have already paid deposited 4 lakhs.
Where you are
Right.
reading? Where you?
Para number 6.
Para number 6.
Yes, sir. The department out of the awarded amount has already deposited in court a amount of rupees 4,04,719.
This was not referred to in the order.
No, this was not referred.
Before Justice Sen,
Yes,
this
my lord.
you did not submit.
Yes, my lord. The department has intimated that they have deposited in the court, in the trial court.
They have come forward with the check which was not.
They have refused to collect the check.
Deposit to them.
However, we will deposit the entire awarded amount, my lord.
What is the entire awarded amount?
Here it is 39 lakhs 28,020. Para 1. Para 1 I have mentioned the award amount.
You already have 4 lakhs with you.
Yes.
That they have not collected.
No, not collected.
So that amount is with you.
My lord.
Remaining amount you have to.
Yes, my lord.
What is the explanation you have given?
This is the financial year in para 9. Additional fund could not be availed by the department. And as such request the Honorable Court to extend.
11th March was the order.
My lord.
You filed the application when?
Within 2 weeks, my lord. Within 2 weeks I have filed it. Filed it on 25th. 25th March.
Because the লম্বা ছুটি। আর ছোট্ট যদি দিস। Yes, Mr. Das, what do you say? You can or you cannot execution of the award will also take time.
I'm not on that. It is a matter pending since 2019.
No, that may be in
Now,
before.
my
the-
second part is, para six में pending with.
Yes. Para 6, yes. But you said that you have not received.
No, para six of the order.
Yes.
11 March. There shall be an unconditional stay of enforcement of the ensuing award for a period of 2 weeks from date. In the event that digital amount is secured by furnishing the bank guarantee with the registered certificate about the same shall be stated in the dispute of the. My humble submission. What the 2 weeks was elapsed, the unconditional stay is gone.
What
So,
steps you have taken?
That is,
You have to execute the award now. That will also take time for you.
that is, when this is just there, on the plea of this appeal.
What is pending before the, yes,
Plea of this appeal, that is pending.
but you have to appreciate the year ending is also there, Mr. Das.
I leave it to my lord, but, July, such time. is,
We will give you 8 weeks. Within 8 weeks, you make the payment.
All right, my lord.
The present application.
Another part is there. Intent arbitral fraud is not included in the paperwork furnished by the
What, Mr. Shivalam, you have not annexed the
entire arbitral proceeding, statement of claim, statement of defense. That would be definitely required. for-
You ascertain?
I shall file the supplementary paper book, my lord.
In both the appeals, you have filed the paperwork.
My lord.
Huh?
Yes, my lord.
So same
Same. Both the
that is incomplete.
appeal I shall file.
Present application being CAN 3 of 2025 has been preferred by the Which matter also it will be the same, no?
Same, my lord, only letter dated is 17 March instead of 13 March. Department letter.
In the
dated-
other one also you put in the same order, but make it 17th March, that is
I'm looking for the petitioner.
Yes. Page 405. Mr. D'Cruz, we will give them an opportunity to reply to your jurisdictional issue. Because that is the sole issue remaining.
Yes, yes.
Your original application was dismissed, your review application was dismissed. Then you came before this court. In this court, you argued that that superintendent had no jurisdiction to even to issue the charge sheet.
Yes.
In terms of the appendix to the rules. So we will ask them to answer to the said issue within a particular time, so that the matter can be heard. We were desirous of disposing it of, but I think they should be given an opportunity to use an opposition.
Yes, madam.
Then we do that and we fix in the desert. Acha, records reveal. Yes, Mr. Chakraborty, you have anything to say? But Mr. D'Cruz, what is the number of the review? You prefer WPCT 10 challenging what? Both the orders of review and original?
No,
Only the review was challenged.
Review order was
challenged.
So, my lord, the honorable bench said that this you can take this as a point while challenging the main order. So now they have belatedly challenged the main order as also the review order which they had earlier challenged.
That order is at page number 405.
No. Where is that? You are challenging both the orders.
Both the orders.
Yes.
342 is, my lord, the main order.
Can you give us the dates of
Yes,
the
my
order?
lord. 342. This is 26th February 2024 is the order passed in
26th February.
2024. Order passed in OA 351/1260/2022. And my lord, the second order is the order passed in review, which is 392.
One is 342 and the other is 392.
Yes, my lord. 392. 386. Okay.
392.
392 or 386, same order is there. 7 January 2025. Passed in RA number 50 of 2024 with MA 1110 of 2024 in OA 1260 of 2022. And my lord, the Honorable High Court's order, my lord, is at 405. Page 4, the predecessor in the earlier.
Records reveal that a coordinate bench of this court, while considering the writ petition being WPCT 10 of 2025, preferred challenging the order passed in the original application, orders passed in the original application and the review application, comma. The court directed that quote unquote, directed that the original application is required to be heard on the limited issue with regard to the applicability of Rule 9.3 within bracket small b read with Rule 9.1 within bracket Appendix 9.1 of the Andaman and Nicobar Police Manual 1963.
My lord, really sorry, my lord, but I must point out that when this, if my lord sees 20th March 2025 order, at this stage, they are not challenged the order passed in the OA. They had only challenged the order passed in the review. So, my lord, this is in the.
This one we are asking you.
Yes, that is what I'm submitting, my lord. And my lord, the honorable court said that you gave them liberty to say, to challenge both orders because review itself, my lord, standalone, my lord, it was not maintainable. If my lord sees the order at page 405.
No, we will say it is the prayer is of 26th February 2024. Prayer is you set aside that original. Page 22 of the application. He has again challenged the entire proceeding along with the order of the original.
Oh, but my lord, this is the first time he's challenging 26th February 2024. That is what I'm submitting, ma'am.
No,
Earlier what
26th February.
26th February 2024 is the order passed disposing of the original application.
Right,
What happened after this is he filed a review before the CAN.
right.
The review was dismissed, my lord.
Yes.
When the review was dismissed, he filed WPCT 10 of 2025, only challenging the order dismissing review.
Where do we find that?
Well, that is, my lord,
Come now, in sync with what you have submitted, see the prayer, page 20. It doesn't matter, Mr. Chakraborty.
my lord.
It's a recording because when the argument will be made, your attention will also be drawn to the review order passed.
My lord, my lord.
We have only recorded that challenging both the orders, this has been filed and the court has directed this.
Angelina.
What is that selection matter?
Yes.
That, so we admit it, you use your pleadings are complete.
Yes, fresh.
Are your pleadings complete?
Yes, my lord. Pleadings come, this is WPCT, my lord. We have not filed any pleadings here. No,
Not required, no?
no, usually not prepared. On the paperwork direction is there.
Yes, so we can direct for filing paper.
And-
Where is she? All right, pass. एक ही password होगा. You don't need to do it.
Item number 6. Implemented 2 of 2024.
Just bringing this paper to point.
Sound, Mr.
I could not find Mr. Khan Saab. I could find him from the low court. Very with the matter, it can be taken up. The issue is very limited, you know. Order of remand is challenged in this.
No, but if it has not been given, Mr. Jaipal, it has to be, has he received it?
Let Khan Saab comes first, let Khan Saab.
Pass over. So his surname now is Khan Saab, not Khan only.
And I normally listen to Khan Saab. I'm sorry.
Yes, next.
Item number 7. Implemented 2 of 2025.
I am for the appellant.
Yes, Mr. Rosa.
My lord asked me,
Mr. B,
yes, my lord, the matter is pending in SLP, Supreme Court,
yes, another matter,
is fixed on 15/4.
15th of April. দেখি ফাইলটা একটু দাও. You are there, Mr. Jaipal?
And then I've already entered into office.
First order may be seen, my lord.
Records reveal that when the matter was earlier taken up
Mr. Kumar appears for the other side. I think he's outside. So Mr.
What is
Kumar-
the matter about?
Some papers are incomplete, my lord, I think. Papers are not complete, my lord. If my
You
lord,
are the
Petition.
appellant, writ petition. What order have you challenged?
incomplete papers, my lord, may permit us to
Oh,
file the complete papers.
take
on
care.
this.
Oh, we fix the stay application.
Stay, my lord, let it, we'll come to file the papers, my lord. Incomplete papers are there, my lord. Leave may be granted to file the complete papers and my lord, let it come in the next circuit, my lord.
So we dispose of your stay application.
Let it be there, my lord, yes. Because papers are not complete, my lord. Stay, it will be stay of order, my lord. So let it be, my lord, kept for the next circuit one.
As prayed for by Mr. Chakraborty.
Nineteen of 2025. Passed by Honorable Justice Amrita Sinha and Honorable Justice Uday Kumar.
Oh, then
Page 11. Rest may be directed to place. Page 11.
the present appeal arises out of the present contempt application has been preferred The present writ petition কোনটা পাসওয়ার্ড কোনটা আছে আইটেম মিস্টার জয়পাল আছেন আছেন কি করে কালকে
Item number 11,
Here, my lord,
10 of 2024.
there was a direction upon us to file the affidavit, supplementary affidavit. We have filed that, my lord. Served on the other side if they want to.
I have to file reply. I think what happened, Your Lordship? The fight is with regard to 13 posts,
yes that OBC
OBC, that
Uh.
one. Now they have come up with a new calculation. They say no, 2 more posts should have been gone to the general category. So under such circumstances, whether they have given a copy to Mr. Tabriz or not, I don't know.
This affidavit helps the petitioner, my lord, at least
I'm
to
not
the
saying
extent
that.
of.
No, I'm not saying that.
how it is helping them
Because, my lord, we have, the affidavit admits, my lord, that by error, my lord, what happened is person with disability quota, my lord.
they have
Was,
been included
no, they were, my lord, separate, treated as a separate category rather than distributing them amongst the other. The law is, my lord, that they have to be distributed amongst the different general category, SC, ST,
Horizontal
SC.
vertical
So
reservation.
instead of doing that, they have been treated as a separate category. So because of that, so if that is accounted for, there will be 2 more seats which will be available.
does that bring her within the zone of
No, no,
consideration
that will only,
reward the undeserved
there are several petitioners here.
Unreserved, we are 13 in number.
13 people, at least.
You are PWD.
There is an injunction, yes. Sir. No, this is forest. Forest department. Here, my lord, there is an injunction, so
They
they
are protected within.
they are protected. Now, 13 seats are protected.
I don't know, Your Lordship, because the thing is that
all right video file
We have filed affidavit.
কোথাও দিয়েছে
Hey,
আচ্ছা মিস্টার চক্রবর্তী লার্নেড সিনিয়র অ্যাডভোকেট
नहीं नहीं परदेसी
সারা বিশ্বে সব ইয়ে করছে এখন রেকর্ড হচ্ছে কি কোন রেকর্ড লাইভ স্ট্রিমিং আরেকটা যেটা পাস হওয়া ছিল না জয়পাল কোথায় গেল জয়পাল তাহলে ঠিক আছে নেক্সট ডাকো আরেকটা কি ফার্স্ট অ্যাপিল ছিল না ডাকো 11 নম্বরটা ডাকো
Item number 12.
Yes, sir. Petitioner's advocate, Mr. Sabir, I am told is unwell, my lord. Let it go to the next circuit. Let it not be.
He was admitted in the hospital.
ও মাই গড
I am appealing for private response. I filed my opposition.
দেখি একটু রেকর্ডটা তো
There is no interim order. He does not, he will not gain by the pendency.
you filed your opposition
And I have served the copy also.
opposition to
To
the
Modi, his junior, I have served. to
you are the private respondent
My lord. Tribunal, I have not received the copy, so I have not appeared here.
हम लोग अलग
अच्छा देखो Mr. Kumar Learned Advocate appearing for the
Item number 13.
Yes, that my lord, the petitioners are not interested because my learned advocate on record had informed Mr. Bharat Bhushan also. But it seems that my lord, they are not interested, my lord. It can be dismissed, my lord, for non-prosecution. If they want to revive, my lord, they can revive. Or the constitution adjourn to the next.
Degi filed
I have not difficulty. Several dates it has been adjourned. It can be adjourned also, my lord. I don't have, there's no interim order.
CTT का सारा पोस्ट को fill up होगा.
Posts are also filled up, maybe because of that, my lord, because they, here, my lord, they wanted age relaxation, but the process is completed, so nothing survives in this matter, my lord.
oh it was directed to go out of এইটা কি মেনশন করেনি বলে এসছে না
Let it again go out, my lord, of the list.
Let me sign it out. नहीं आप बिल्कुल sign it out.
let this matter মেনশন করলে এগুলো আমি বলেছিলাম দেখতে মিস্টার অতীন্দ্র মিশ্র
Item number 14,
14.
WPCT 44 of 2024.
Yes.
Finding the victim.
Given copies. Given copies. Copy.
We have
given.
received copy, my lord.
Yes, what is the matter?
The matter related to the disciplinary proceeding.
Mhm.
This is our proceeding. But to cut short the matter, I would like to place the decision of the appellant. Instead of going into deep into the matter, you should kindly come to the decision of the appellant. Page number 262.
No, just give us a broad outline. What is the matter about?
The petitioner, he was dismissed from service on the ground that did not listen to the authorities' direction. That at that relevant point of time, he should not go and seize the materials. He did not listen. He
Stop
was
this side, take the mic.
He was under the influence of liquor at that relevant point of time. And he also demanded bribe from the private persons. These are the three article of charges. On that ground, he has been dismissed from service.
He is a working.
He is constable.
Hmm.
Let me acknowledge. Then we have placed the matter before the disciplinary authority initially. Initially, the disciplinary authority dismissed the petitioner from service on the relying upon preliminary inquiry report.
Hmm.
Relying upon preliminary inquiry report, he was dismissed. This matter came up to this honorable court. This honorable court said that no, on the basis of preliminary inquiry report, you can't do it. You cannot reproduce what has been written, what statements have been given in the preliminary inquiry report, inquiry proceedings, and relying upon that statements, you cannot dismiss a person. Matter was remanded. Thereafter, again, the examinations were done. The witnesses were examined. At that relevant point of time, the higher authority said that he has given direction to the petitioner to not to seize the materials. That is, there were some arachnids and all those things in the tribal area. Not to seize those materials. That direction, what has been given, he has not been examined. He was not examined.
Who was not examined?
The higher authority. The superintendent of police was given the direction not to do this, not to seize the materials, items.
Yes.
So he was not examined. That was one of the points. Then the rest, all the persons are those persons who have been carrying out illegal trade of arachnids.
What is arachnids?
The supari, net, beetle. So that beetle net, that
The other persons were examined.
other persons were examined, they were cross-examined also. There was several discrepancies in the cross-examination.
Hmm.
All those things were projected before the disciplinary authority. Disciplinary authority considered the entire thing and dismissed it from service. I filed an appeal. Now, your lordship may kindly come to the appellate authority's order. There I want to page 262.
ও এটারই তো পেপার page 262, yes.
Your lordship, the up to 266. Only and whereas what has happened, it has been stated. Up to 266. The last paragraph is, I have gone through the records of the case and the contentions put forth by the appellant. Based on the same, the undersigned does not find denial of reasonable opportunity for defense during the process of departmental inquiry conducted against Shrestha Singh. And also there is no merit in the contention of appeal, and the order is not in conformity is with facts and law. That's it. Not even a single ground of the appellant has been discussed in the entire order. This is the last.
Each and every ground has to be discussed.
Yes, I'm relying upon the decision of the Supreme. There is settled law, no need to rely, but I have the decisions.
But he was under intoxication at the ready bed time.
No medical examination.
Yes.
Go ahead. If Supreme Court.
Because I think the order of the disciplinary authority should be placed, my lord. And the order of the cat, my lord.
Yes, Mr. What is this here?
And I have specifically pleaded in my tribunal's application about the said thing, page number 76.
There is a contrary judgment also, Mr. The detailed reasons are not to be given.
At least some reason. No reason is there. It's basically cryptic order. And page number 76, grounds before the tribunal.
These are the two judgments you are relying for non-speaking order.
Yes, sir.
Hmm.
Exactly the same position about the appellate authority, that both the judgments are relating to departmental proceeding, where the appellate authority did not discuss the grounds raised by the appellant.
Oh. তাই তো করেছে।
And page number 76, your lordship. These are the grounds which I have taken before the tribunal about the appellate authority's order.
Page 76.
76.
Hmm.
C and D,
Non-speaking and
unreasonable.
unreasonable. The same ground.
They may say that before the tribunal, I have not taken this ground. So that's why I wanted to show them.
C and D is same.
Yes. If ultimately, your lordship, I am going to the evidence and everything, and thereafter, this is the ultimate conclusion, your lordship, the matter has to go before the appellate authority again. This honorable court cannot adjudicate relating to the all those things, evidence and everything. This honorable court cannot look into it because the appellate authority has not discussed even. So that is the reason why I wanted to cut short the matter and want
So
to.
how did the tribunal deal with that argument of yours? How the tribunal dealt with that argument?
Cat.
Yes. Page number 421, paragraph 3.1. This is my argument. I wanted to show that I have argued the matter. This was my argument.
Page 320.
21, 3.1.
Order of punishment is dismissal. Dismissal.
It has not been dealt with. The entire order is the tribunal rests upon the order of the disciplinary authority. The complete order speaks only about the decision taken by the disciplinary authority, as and the manner the disciplinary authority dealt with the matter. Entire judgment.
Where have you taken that the SP was not examined? 2001 dismissal order was of 2001.
Your Lordship.
What is your age now?
Your Lordship, the 50% in retirement benefits I may get. That is the only thing. I think possibly he has attained 60 years possibly.
Hmm.
But Your Lordship, if suppose merit is there in the matter, then this honorable court can grant 50% of the salary and the retirement benefits. That is what is granted, Your Lordship.
Your entry in service was any antecedent you had?
No, this is the only one.
When did you enter into service?
1982.
1982.
Yes.
Where is the earlier order of the High Court, 7th March 2006?
One 127.
No, earlier High Court order was that you challenged the, what did you challenge there?
There also dismissal order was challenged.
Of the disciplinary authority.
Yes.
You did not go up with
Appellate. After appellate authority's order only, I preferred the application before the tribunal. Tribunal rejected my case, then I filed the tribunal allowed my case, and then the Union of India filed the appeal before the dishonorable.
Will you please place that order so that the facts would?
Yes, Your Lordship. Tribunal's order
127.
127. Yes. This is an application under Article 226 and 227 of the Constitution of India against the judgment and order dated 16 September 2005 passed by the Central Administrative Tribunal in original application number 37 AN 2003. Brief facts leading to filing of this application are as under. In February 2000, the petitioner was posted as officiating station house officer. It is alleged. Got it? It is alleged that on February 25, 2000, at about 11 p.m., one K. Henry Samuel and one Rajiv Biswas of HSK Enterprises Trading Company complained to him that certain persons were carrying out illegal trade of supari. The delinquent took the complainant to his official residence and consumed liquor and had a dinner together. Thereafter, the delinquent informed the Superintendent of Police Kanikobar over telephone that he had received a complaint regarding illegal trade of supari and copra and expressed his intention to take actions against the illegal traders. The Superintendent of Police Kanikobar directed the delinquent not to take any action on such verbal complaint and further directed him to produce the person concerned before him in the morning. It is further alleged that the delinquent officer disobeyed such instructions of his senior officer and arranged for a private vehicle and went to Barka village along with the police party on February 26, 2005 at about 5 a.m. and sealed the godown of HSK Enterprises Trading Company without observing the legal procedures. Thereafter, he demanded illegal gratification from SDR traders, and as the proprietor of SDR trader refused to give such illegal gratification, he sealed the godown of SDR traders and seized 6 bags of safari on his own account. Thereafter, the delinquent officer went to the residence of one Munir Ahmed and demanded rupees 20,000 as illegal gratification. As the said Munir Ahmed refused to give such illegal gratification, he seized 8 bags of safari belonging to the said Munir Ahmed without observing legal procedure. It is alleged that all his actions were unjust. The Superintendent of Police placed the delinquent officer on suspension with effect from February 29, 2000. In the meantime, the Superintendent of Police held preliminary inquiry and he found the delinquent officer disobeyed directions of the civil officer and on his own account, under the influence of liquor, initiated actions which had no legal basis, and he did so without following proper procedure for sealing of godown as well as search and seizure. However, the Superintendent of Police found the allegations of demanding money could not be substantiated as the money was neither given nor taken. The Superintendent of Police, in course of such preliminary inquiry, recorded the statements of certain persons. The matter was referred to the disciplinary authority, namely Inspector General of Police, Andaman and Nicobar Islands, and the disciplinary authority proposed to hold a departmental inquiry. The charge sheet was issued. The Deputy Inspector General of Police, Andaman and Nicobar Islands, was appointed as the inquiring officer. The delinquent officer appeared before the inquiring officer along with his defense assistant. The inquiring officer submitted his report on 16th August 2001, holding inter alia, and the charges framed against the delinquent officers could prove beyond any reasonable doubt. The matter was then placed before the disciplinary authority, and the disciplinary authority confirmed the proposal of punishment of dismissal of the delinquent officer from service with immediate effect by his order dated December 20, 2001. The delinquent officer submitted representation to the appellate authority. The appellate authority, namely the Lieutenant Governor Andaman and Nicobar Islands, by an order dated 5th July 2002, dismissed the appeal, holding inter alia that he found no reason to differ with the disciplinary authority, and therefore the order of the disciplinary authority was upheld. Being agreed, the delinquent officer prepared an application under Section 19 of the Administrative Tribunal Act 1985 in the Central Administrative Tribunal, which was registered as original application number 27 AN 2003. By the Indian law dated 16 September 2005, the Central Administrative Tribunal allowed the original application to present the inquiry report, order of the disciplinary authority, and order of the appellate authority. The case was remitted to the inquiry authority for conducting further inquiry on the charge sheet. Being agreed by the order of the Central Administrative Tribunal, the administration has filed this application under Article 226 of the Constitution of India. Mr. Santosh Kumar Mandal, a government period, submitted that the Central Administrative Tribunal did not apply the proper legal test and erroneously upset the inquiry report, order of the disciplinary authority, and the order of the appellate authority merely on the ground that the inquiry officer did not take any fresh evidence during the inquiry after the charge sheet was issued to the tribunal, considered it as a major procedural lapses and held that the entire proceeding was initiated. Mr. Mandal submits that the statement of witnesses were recorded during the preliminary inquiry on 26 February 2000 and 27 February 2000 were taken on record in the disciplinary inquiry held on 2nd December 2000 and 4th December 2000. The statements were read over the said witnesses and the witness accepted their statements. The petitioner and his defense assistant cross-examined the said witnesses. He submitted that the Central Administrative Tribunal proceeded erroneously on the basis of the decision of the FS Court in the case of Union of India and others, was Muhammad Ibrahim, reported in 2004, volume 10, SEC 117. He submits that in that case, the inquiry officer proceeded on the evidence of the witnesses recorded in the preliminary inquiry, and the witnesses were not produced before the delegation for cross-examination. Therefore, Muhammad Ibrahim has no application in fact and circumstances of the incident. Mr. Mandal submitted that the inquiry officer committed no mistake in taking on record the statements of the witnesses recorded in the preliminary inquiry in view of Central Civil Services CCS rules under Rule 27 of the said rule. Statement of witnesses recorded at the preliminary inquiry investigation are to be read over to them and got admitted as evidence. Ms. Anjali Nagaran, advocate for the delinquent officer, submits that the inquiry was not held properly. The inquiry officer did not notice that some of the witnesses who gave their statement during the preliminary inquiry stated that their statements were not correct. The said Henry Sevel submitted in course of disciplinary inquiry that he had not given any complaint against one Anand. Rajiv Biswas, another witness, also denied his statement. Ms. Anjali further submitted the Central Civil Service Classification Control and Appeal Rules saying no application in this case in as much as the delinquent officer was a member of police force and his service is governed by the Andaman and Nicobar Police Manual 1963. She submits that it was incumbent on part of the disciplinary authority to conduct the inquiry in terms of paragraph this of the said manual. That is enough that the inquiring officer should have taken oral evidence as may be relevant and or material in regard to the charges. We have heard the learned advocates for the party and have produced the materials on the report. In our view, the inquiry ought to have been conducted by the inquiring officer according to the Andaman and Nicobar Police Manual, 1963. Charge sheet was issued under paragraph 9.3 of the said manual. Then this manual, may I read this?
No, not required. Then next page,
Next page.
clause F was taken into
Yes,
consideration.
in the sub paragraph F of the 9.3 of the said manual, the inquiry officer shall in the course of the inquiry consider such documentary evidence and take such oral evidence as may be relevant or materials in regard to the charges.
So just pausing here, the inquiry officer simply relied upon the recordings made in the time of preliminary inquiry.
Yes.
That is the case.
That is,
And the inquiry officer did not examine any witnesses.
no,
All the witnesses and everything was before the preliminary inquiry authority.
yes.
So the preliminary inquiry authority was the same as this inquiry officer or different person?
No, different person. Different person.
Very good. Our reading of the rules.
Our reading of the rules is that disciplinary authority ought to have recorded the statements of the witnesses in course of the disciplinary inquiry. He should not have simply read over their statements allegedly made by them during the preliminary inquiry to such witnesses and obtained their acceptance. The inquiry report is based on the statements of witnesses.
No, why it is said that the disciplinary authority of the
Inquiry authority should have
it
been.
should be inquiry. no?
The inquiry report is based on the statements of the witnesses recorded during the preliminary inquiry. Moreover, inquiry officer did not notice that some of the witnesses in their cross-examination during the disciplinary proceeding denied their statements made during preliminary inquiry. Therefore, the Central Administrative Tribunal was right in holding the inquiry officer proceeded erroneously and his report was not sustainable. As the Central Administrative Tribunal found there was a major lapse of procedure and the entire disciplinary proceedings were initiated, the tribunal was justified in setting aside the report of the inquiry officer and the constitutional orders passed by the disciplinary authority and the appellate authority. We do not find any merits in this application filed under this is the application is therefore dismissed. The order is affirmed. We direct the parties to.
So the tribunal remitted the matter again to the inquiry officer.
Yes. Yes.
Achha, then what happened?
Yes, just. Then thereafter, your disciplinary authority conducted the inquiry. Disciplinary authority conducted the
No,
inquiry.
it should go back to the inquiry officer.
Yes. Inquiry authority. That is, it goes to the disciplinary authority and then the inquiry officer will do the entire thing.
Yes.
So inquiry officer conducted the inquiry again. Some of the witnesses could not come. 3 witnesses who were examined during those days. Yes, that time they were not examined. Some other witnesses were examined.
Fresh witnesses.
Fresh, not fresh witnesses. Out of 10, 12 persons, 3 did not come. Rest were the same only. Rest were the same only. No new persons were added.
Yes, and found you guilty.
Yes.
Then you went to the, then you replied to the inquiry report.
Yes, it was.
Then it came to the disciplinary authority.
Yes.
Now the disciplinary authority
Dismiss me.
against that non-speaking order of the appellate authority, which you assumed.
Yes, before the tribunal.
Achha. So please show us the disciplinary authority order,
Yes.
which is at place.
230. 230.
This order Shubhodar pass করেছে 7th March 2006.
In between, one more thing happened, Your Worship. The
Yes.
disciplinary authority dismissed me without any reason, without recording anything. Unreasoned order. I filed an appeal before the appellate authority. Appellate authority remanded the matter back to the disciplinary authority.
Sure.
Yes, Your Worship. This is page number.
একটু শার্পেন করে দেবে।
The first order is page number 219. 219.
No, High Court passed the order on 7th of March 2006. Now it came back to the disciplinary order. 219.
219.
This is the order after High Court order.
after High.
After inquiry was completed, then
This is the order.
yes.
So it was basically a non-speaking order. Even this disciplinary authority did not discuss the evidence led during the inquiry, and therefore appeal was filed. And the appellate authority's order is at page number 227. And 229 is the operative portion.
Same type of order. Whereas only one paragraph. That went in your favor.
Then 229 remanded to the disciplinary authority.
My lords, the reasons are contained in whereas, my lords. That is the format that they're using here. Only the conclusion does not have whereas.
I don't think that in the appellate authority's order, which I am challenging now, even the whereas contains any reasons.
All
I'll
right.
show you. Now, page number 230 is the order which has been passed
Upon remand.
upon remand by the appellate authority.
Yes.
Now, your lordship, after that, the disciplinary authority, your lordship, passed a detailed order, no doubt about it, a detailed order was passed.
So against this, you went up to the appellate authority, then that resulted in this order, page 262.
260.
My lord, I will place certain parts of this order when I am submitting my.
Yes, yes. Now, kindly take us to the tribunal's finding. That is page 420.
417 it begins, my lord.
The begins.
Yes.
But, where is the finding?
The 420, 423 bottom and then 424 onwards.
My point which I have raised, that has been discussed in page number 435, 8.4.
That non-examination.
Yes, that without examining the grounds, discussing the grounds raised by the appellant, without giving reasons for that, the disciplinary, the appellate authority has just affirmed the order of the disciplinary authority.
Madam, please show us from finding, start from paragraph 6. Any relevant portion you want to show us?
Yes, Your Lordship, that where it has been discussed I have argued that I have already shown 3.1.
Hmm.
And the discussion is 435 from last line.
No,
435.
428 also maybe.
It is
Placing
a
the
final
order.
decision.
Yeah, I have to place it again.
420.
428. 428 para 8.1 onwards.
That you will place whatever
No,
the
8.1 is not the point which I have, my point was that the appellate authority.
no, we understood you have taken 2 points. First, the SP was not examined, neither before at the time of preliminary inquiry nor at the time of inquiry. Second is that the appellate authority order is an cryptic order. And as such, you send it back to the appellate authority.
Many things are there. The disciplinary authority held that I have admitted my guilt by way of a letter. That letter speaks something else. There are many things.
Show us that.
Your Lordship. That's why one by one I just want.
Mhm.
I'll show it.
Acha, you finish this up, page 435, you said.
Yes.
It can be 8.4.
8.4.
Yes, please, please.
The last 8.4, the last of from the last word. The appellate authority has also examined the same and while rejecting the claim of
Which page, which one you are reading? Page 435?
for the last word D,
Oh,
option C,
acha, yes.
and then goes to the next page.
Hmm.
The appellate authority has also examined the same and while rejecting the claim of the applicant, the appellate authority did not find any valid reason to interfere with the findings recorded by the DA, mainly on the ground that the said appellate authority did not find any denial of reasonable opportunity for defense during the process of inquiry conducted against the delinquent, and also did not find any merit in the conviction of the appellant. That DA had recorded its findings contrary to the fact as well as law. In view of the above, it can be seen that there is no procedural lapse surfaced during the contemplation of inquiry or the path by the disciplinary authority and the appellate authority. We are of the considered view that the findings reported by the inquiry authority in its reports and the conclusion arrived by the disciplinary are supported by substantial evidence surfaced during the departmental inquiry instituted against the applicant. And thereafter, so this way it has been considered. The point which I have raised.
Now, please come to paragraph 10, please, please.
Paragraph 10. In such aforesaid legal position, it can be construed that in departmental proceedings, the disciplinary authority is the sole judge of facts. Once findings of facts based on acquisition of evidence are recorded, the court tribunal may not normally interfere with those factual findings unless it finds that the recorded findings were based either on no evidence or that the findings were wholly perverse and are legally untenable. The adequacy or inadequacy of the evidence is not permitted to be canvassed before the High Court or tribunal. Since the High Court or the tribunal does not sit over as an appellate authority over the factual findings recorded during departmental proceedings, while exercising power of judicial review, the tribunal cannot, normally speaking, substitute its own decision with regard to the guilt of the delinquent for that of the departmental authorities. Even insofar as imposition of penalty or punishment is concerned, unless the punishment or penalty imposed by the disciplinary or departmental appellate authority is either impermissible or such that it shocks the conscience of the court, it should not normally substitute its own opinion and impose some other punishment or penalty. In the present case, this tribunal is inclined to adhere to the aforesaid well-settled principle, taking into consideration that in the case in hand, there is no procedural lapse in conducting a departmental inquiry. After granting due opportunity to CEO, the DA in A came to the conclusion that the charges level against the applicant stands approved and deemed fit to award penalty, which was subsequently upheld by the applicant. We do not find any. Now, Your Lordship, even the tribunal basically, in this paragraph 10, Your Lordship, says that so far as evidences are concerned, how it is to be taken into consideration, the grounds raised by the appellant or the person concerned, the evaluation of evidence, all these things have to be done by the disciplinary authority and the appellate authority. The tribunal itself says the tribunal cannot go into it. Judicial review cannot be done by the tribunal or by the High Court. It can be done by the disciplinary authority and the appellate authority. Because appellate authority has to look into the evidence, Your Lordship. That is the last remedy of that anybody, your lordship, the appeal.
No, that is well settled. Up
Your
to the appellate authority stage, they can
Facts,
reapprise the
Yes,
evidence
reapprise the evidence.
because it's the appellate authority.
Now, your lordship can look into the appellate authority's order. Where is the reappreciation of evidence? The points which I have raised, grounds I can play.
So
the grounds.
before that, Miss Nag, what are your other admission points, what you are saying? Do you want to take us to any other page or not?
Your lordship,
Then we will go to the appellate.
your lordship. Your lordship, just.
Or you can find out and show it us in reply if
Yes.
required. So that Mr. Chakraborty can also highlight on the other issues. Or,
I got that one.
yes.
Page number 94. Your lordship, I'm sorry. I think it's not been released.
This Sanjay Singh was not examined. The
Subsequently,
SP,
he has not been examined. Second inquiry, he has not been examined.
first inquiry examined.
Yes,
So did he say that yes, he did, he said that he did not give any instruction to seize?
yes, yes, yes. But that is already gone, your lordship. Everything was quashed by the learned tribunal. Tribunal quashed the entire proceedings and asked to conduct the inquiry afresh. So how can that
So
particular statement?
no, before the second inquiry officer, after remand, SP did not appear.
No. He did not. It's shown.
Right. Appellate authority quashed that order and send it for rehearing, for remand.
No. Tribunal. Appellate authority only with regard to the disciplinary proceeding. Disciplinary authority after the fresh inquiry was conducted. After that, your lordship, when the matter was there before the story is the preliminary inquiry was conducted, disciplinary inquiry was conducted. Thereafter, I was dismissed. I went to the appellate authority confirmed the order of the disciplinary authority. I went to the tribunal. Tribunal allowed it and sent matter back to the disciplinary authority to conduct.
Where is that order? Where is that
Tribunal.
order? Page 227 is the appellate authority order.
Just 118 years.
Against this, they came up in appeal.
They filed the appeal before.
Yes,
Let him submit your lordship, then I will.
all right. No, we just wanted to know. Just 1 minute.
Yes.
What is his age? বয়সটা পাচ্ছি না।
The date of birth of your
Date of birth.
is
Petition we did. So he was 63 in 24. He's already retired.
Yes, your lordship. So 1982 appointment.
Hmm. He was tried under the Andaman and Nicobar Police Manual,
Yes.
not under the CCS, which Justice Mukherjee held that was right, which you argued.
Yes.
So do you have that manual with you?
Yes.
And show us the punishments in that? Do you have, do you have manual? Acha, you start, Mr. Chakraborty.
But my first submission is, my lord, the petitioner has.
No, just 1 minute, just one, sorry. Miss Nag, you show us that in the second inquiry, SP was not examined and there was a letter of admission relied upon. That portion only, please find out and show it to us. Yes, Mr. Chakraborty.
First submission as lordship, my lord. This is a case where the petitioner has admitted his guilt. So, my lord, these points, my lords, perhaps are not available. My lord will see I show from the tribunal's order itself. Those letters I couldn't find on record, but kindly see, my lord, the tribunal has recorded. First, my lord will see page 423, which is the submission of the respondent before the tribunal.
Now, just reiterate the charges. Charge was that.
Charge was, my lord, that I'm in a drunken state.
Can you show us the charge sheet for
So
once?
we cannot see the disciplinary authority order 230, everything is set out.
No, that is a longish order.
I don't know, article of charge is there, page 230. Page 230. That on 25th February 2000 at about 2300 hours. One Shri K. Henry Samuel and one Shri Rajiv Biswas of HSK Enterprises Trading Company at Porta Village, Car Nicobar, came to PS Car Nicobar and verbally complained to ASI Sheshnath Singh, officer in charge of PS Car Nicobar, that one Shri Anand, resident of Malakka, and one Shri Munir Ahmed, resident of Kinyuka, Car Nicobar, were carrying out trade of supari. They suggested that ASI Sheshnath Singh should come and check the godowns of all parties, including the godown of HSK Enterprise Trading Company belonging to Shri K. Henry Samuel, and initiate legal action. ASI Sheshnath Singh took them to his official residence, where all of them consumed liquor and had dinner together. They then conspired and reached some kind of mutually beneficial agreement. To make the above checking look normal and genuine, ASI Sheshnath Singh intimated to Superintendent of Police over phone that he had received complaint regarding illegal trade of supari and copra. On this, Superintendent of Police specifically directed not to take any action on such verbal complaint and produce the persons concerned before him in the morning. ASI Sheshnath Singh, however, deliberately disobeyed such lawful instructions of the senior officer and arranged private vehicles and went to Perka village along with police party on 26 February 2000 at about 0005 hours and sealed the godown of HSK Enterprise Trading Company without observing any legal procedure. Thereafter, he went to the godown of SOR traders in Malakka and demanded 50,000 as illegal gratification. On refusal of such illegal gratification, he sealed the godown of SOR traders and sealed 6
Such and such.
supari on the ground on his own accord. ASI Sheshnath Singh then went to the residence of Shri Munir Ahmed, resident of Kinyuka, and demanded 20,000 as illegal gratification, and on refusal to give such illegal gratification, he seized 8 filled bags of shukuri belonging to Sri Munir Ahmed, which was kept in the veranda of his house without observing any legal procedure. That his such actions of sealing of the copra and supari godowns and effecting seizure of supari without observing any legal procedure relating to sealing of godown, search and seizure, with ulterior motive to harass the businessmen and extort money from them, and that too after ignoring the lawful instructions of his senior officer, speak of grave misconduct, deliberate disobedience, abuse of his official position, and breach of trust on the part of ASI Sheshnath Singh in contravention of the mandatory provisions under Rule 8.45 and Rule 8.47 of ANN Police 8.47 and 8.45 and 8.47 of ANN Police Manual 1963, thus unbecoming of a police officer and rendering him liable for punishment under Rule 9.3 of the Police Manual. Now, my lord, these I have, my lord, I just show my lord this 8.47 and 8.45, my lord. I've got the extract, my lord. I just show my lord the two rules which have been invoked. My lord, wait. Now kindly have my lord will see 8.47. Fortunately, well, I have only 2 copies of that. My lord may only notice 8.45 and 8.47. Both are there. Yes, sir, I have got.
Now, on where from did you come to know about this incident before issuing the charge sheet? Charge sheet contains this entire episode.
Fine.
On what basis the charge sheet was framed?
For that, my lord,
All right, you proceed in your own manner, then you can, yes, what do you want to show now? The
So, my
tribunal?
lord, may kindly see first, my lord, before the tribunal itself, my
Now,
lord.
what did you want to say about 8.45 and 8.47?
8.45, I was just
Regulation.
regular.
Got it, yes.
Now kindly see, my lord, page 423. The in the tribunal's order, page 423.
You have said that he has admitted.
Yes, I'm just showing that, my lord. Page 423, my lord. Para 4.3. And this is the submission of the respondent before the tribunal. It is submitted that disciplinary authority in its order has given ample reasoning to record its conclusion that charges leveled against the applicant stand proof. Applicant in his defense brief dated 2nd August 2019 and written reply dated 30th March 2010 has admitted that he had
Take
defied.
us to those pages, to find out those.
No,
pages.
that's what I'm showing, my lord. After that, my lord will come to page 428. These documents I couldn't find in the paper book, but page 428, my lord, it is set out by the tribunal. One of the letters is set out by the tribunal. Kindly see.
No, the appellant in his defense brief dated 2nd August and written reply admitted that he had defied the orders for pardon.
Now, this too I couldn't find in the paper book, but the tribunal has set out, my lord, one of the admissions.
Page
428, my lord. Kindly see, my lord, para 8.1, the second line, it is not in dispute that the said inquiry report was supplied to the applicant, and on receipt of it, the applicant had submitted his representation dated 30th March 2010 before the disciplinary authority, wherein the applicant has mainly contended that the entire act done by me during my tenure of posting was done in good faith and the same may amount to procedural lapse. I therefore request your good self to kindly take lenient view in my case and sympathetic consideration may also be taken. I further assure that I shall be very careful in discharging my duties to the utmost satisfaction of my superior authorities. So, my lord, he has only pleaded for mercy, my lord. Of course, this whole entire document, my lord, I couldn't find. But his case, my lord, he has already admitted his guilt and has only sought pardon, my lord, before his superiors. Now, kindly, my lord, has the order of the disciplinary authority at page 230. Because my lord, eventually, my lord, the order of the disciplinary authority has been upheld by the appellate authority.
No, Mr. Chakraborty, whether he seized those articles,
Yes, my lord.
did he misappropriate that? Was there any allegation of?
He seized at the instance of a private party and then sought bribe for this act.
No, any that has been proved.
That has been proved, my lord. That is the disciplinary authority's order. My lord, may kindly have the disciplinary authority. Everything is there.
You finish it up with
My lord.
what you want to show?
Yes, my lord. Now, my lord will see page 431, because my lord, if the page 231, if my lord, the disciplinary authority's order is the best document so far as we are concerned, my lord. So, my lord may consider this because eventually, my lord, this is the original authority which has decided the matter. Now, kindly see page 231 onwards. Whereas the inquiry officer,
Page 231.
231.
Oh, you don't want to show us anything else from the order?
No, I was only showing the admission. Now, my lord may have page 231, which is the disciplinary authority's order. I had read the charge, and then my lord will see whereas the inquiry officer, Shri such and such, completed departmental inquiry and submitted his findings and holding that the charge framed against such and such was beyond doubt. Then, my lord, this history is narrated.
This is the second inquiry.
This is the this is the order of the disciplinary authority in this second round.
Pardon, yes.
Second round. Now, kindly see after that the history is narrated up to page 232. Then my lord will see the fourth paragraph at 232, a statement of imputation of grave misconduct and gross indiscipline on which the article of charge was based, together with list of documents by which and list of witnesses by whom the charge was proposed to be sustained was also given to him along with the above said memorandum. Shri Dr. Such and Such IP, Superintendent of Police, was appointed as inquiry officer. Then my lord will see the disciplinary authority had supplied copy of inquiry report. Then written reply 30th March. Then my lord will see on the next page. My lord, then again that history is narrated. Then my lord will see after that. Now in pursuance of the order, the second last paragraph at page 233. Now the reasoning begins. Now in pursuance of the order dated 4th May 2011, passed by the appellate authority, I have re-examined the entire disciplinary proceedings on record, perused the inquiry report submitted by inquiry officer, the points raised by the charged officer in his defense brief dated 2nd August 2009 and in his written reply dated 30th March 2010. On perusal of the articles of charge framed against the delinquent officer, mainly the following acts of misconduct alleged to have been committed by him. 1. The delinquent officer had deliberately disobeyed the lawful instructions of senior officer of the rank of superintendent of police. 2. The delinquent officer, in a drunken condition, had performed duties. He acted on his own record, sealed the godowns and seized the bags filled with betel nuts of SOR traders and one Shri Munir Ahmed without observing legal procedure with ulterior motive for personal gain. The delinquent officer Sheshnath Singh had demanded illegal gratification from the traders. Now the above acts of misconduct committed by the delinquent officer are examined and evaluated as under. In respect of the misconduct of the delinquent officer mentioned above, that he had defied the lawful instructions of the superintendent of police, the relevant portion of the statement of Shri Sanjay Singh, the then superintendent of police, deposed on 3rd October 2008 is reproduced below. ASI Sheshnath
during preliminary inquiry. 3rd October 2008. When was the preliminary inquiry? Preliminary inquiry report is page 96. 96 preliminary inquiry report was of date of what is the date?
Oh, that is 2000, man.
No.
That is earlier.
Your Worship, I want to clarify this. Sanjay Singh was examined.
Yes.
I was really, actually Sebastian was not examined. So that is the reason why I got confused with regard to it. One was the driver, who was the police officer. I'll tell that.
So now this SP's version is correct. He has been examined.
He has been examined.
But he did not give any instruction.
Yes, he said so.
So that much is that is on record.
That is on record.
Very good. Maybe you show us what you will. You show us any other infirmity?
Yes, I will
because it is a very voluminous paper.
Your Worship, I will show the infirmities, Your Worship, then.
My lord, I'll just place this order.
Yes. Just Mr. Chakraborty, can you help us this? We want to know this sequence. Charge sheet date was.
My lord.
Your junior will prepare a list of dates and give it to us. Yes, you proceed, page 234.
Now, my lord will see. In respect,
Superintendent of Police
Yes.
W9 deposed. Yes.
deposed on 3rd October 2008 is reproduced below. ASI Sheshnath Singh had informed me over telephone in that night he received a complaint regarding illegal trade of copra and betel. I have directed him not to take any action at the moment and to produce the concerned complainants before me on the next date morning. The ASI Sheshnath Singh disobeyed my orders and he himself acted on the verbal complaints. In this regard, the delinquent officer Sheshnath Singh in his defense statement had deposed as under. Kindly see, my lord, his defense statement is set out. I have informed Superintendent of Police over telephone from police station that one complaint has been received to me regarding supari trade. On this, Superintendent of Police had asked me to produce the complainants on the next day morning and he had directed me not to take any action. I had no knowledge that license is not required for doing betel nut business in Car Nicobar. On the complaint of Sri Henry and Rajiv Biswas, I took such an action in a hasty manner unwisely. His own statement. I am pleading for pardon, keeping in view of the future of my children. I may kindly be pardoned for once. I shall not repeat such mistake in future.
No, if any action is taken in good faith, maybe there is a mistake.
No, but
That be protected.
No, but-
Everywhere this action is protected. You see, legal framework. If any action taken in good faith.
that, my lord, in equity jurisdiction court can do, my lord, but the disciplinary authority is bound by the police regulations, my lords. So under the police, police is expected to be to be completely. Can it be said that somebody goes drunk and disobeyed his superior and
That has been proved. The drunken.
he's
Drunkenness.
so far as the
Yes, we have
for-
seen this.
Yes, ma'am. Then, my lord, the inquiry officer in his report has held that ASI Sheshnath Singh was clearly directed by Superintendent of Police not to take any action on the complaint and to produce the complainants before him in the morning, as the matter was not that serious to warrant action at such odd hours. Rather, it was a general complaint and did not disclose any urgency. In fact, Sheshnath Singh had not accepted the verbal direction given to him over phone. It is therefore clear that he took action deliberately with ulterior motive, did not procedure legal procedure, as per law, had disobeyed. The delinquent officer in his defense brief dated 2nd August 2009 and in his written reply that dated 30th March 2010 never took any plea in his support with regard to his misconduct, and he himself was accepted that he defied the orders of Superintendent of Police and prayed for pardon. From the above, it is clear and unambiguous the delinquent officer had defied the lawful instructions. His misconduct proved beyond doubt such an act of delinquency is unbecoming of a member of a disciplined police force. Now coming to the second misconduct, as my lord had fallen from your lordship, my lord. Now coming to the second misconduct of the delinquent officer, that he was in a drunken condition when he took the action, acted on his own accord, sealed the godowns and seized the bags filled with betel nuts of SOR traders and one Shri Munir Ahmed without observing the legal procedure with an ulterior motive for his personal gain. In this regard, the relevant portions of statement deposed by H.C. Pujan Prasad is reproduced below. At about 8:30 to 9 p.m., self took tiffin with meals for Sahab, ASI Sheshnath Singh, to his quarter. At that time, Sri Rajiv and Sri Henry were present in the room. They and Sahab were drinking, which appeared to be liquor. Thereafter, I went to barrack and slept. At about 11 to 11:30 p.m., the sentry had woken me up and informed me that Sahab ASI Sheshnath Singh had called me. On reaching there, I found many staff was present and I came to know that a raid was to be conducted. I, along with Sahab, Sri Henry, Rajiv and other staff boarded the Omni and private truck and reached Rajiv's house. Sahab got opened the godown and after inspection, the godown was sealed. Thereafter, we went to Anand's godown and sealed his godown. After that, we went to Munir's house and Sahab asked him to show the permit of doing copra and betel nut business and seized the 5 to 6 supari bags and I loaded into truck. During the examination in chief of PW6 on the question whether any seizure memo was prepared, while seizing the goods, the witness stated that in my presence, no seizure memo was prepared and simply directed them to come to police station next day morning with the documents. During examination of PW6 by inquiry officer as to whether he had felt that ASI Sheshnath Singh had consumed liquor and whether smell of liquor was coming out from his mouth, the witness stated that yes, from the smell coming out from the mouth of ASI Sheshnath Singh, I felt that he had consumed the liquor. The relevant portion of the statement of Sri Henry Samuel, PW2, is as under. Rajiv Biswas told me that ASI Sheshnath Singh was waiting for us. I, along with Rajiv Biswas, went to police station in a scooter, and from there we went to the residential quarter of ASI Sheshnath Singh. Rajiv Biswas was holding one bottle of liquor with him. All of us, including ASI Sheshnath Singh, started consuming the liquor. ASI Sheshnath Singh called one constable and ordered for meals. Thereafter, we had consumed liquor and we had a dinner together. I was directed by one constable to sit in the Omni. The said constable hinted Shri Rajiv Biswas to be present in the godown. The above statement of Shri Henry Samuel has been corroborated by Shri Rajiv Biswas. The relevant portion of the statement of Shri Rajiv Biswas is as under. At about 8 p.m., a telephone call was received from ASI Sheshnath Singh, directed me and Henry Samuel to meet him at police station. We went to the police station office. From there, ASI Sheshnath Singh took us to the residential quarter. We
But
opened.
where is the complaint, Mr. Chakraborty? That Rajiv and Henry lodged a complaint. But there is no complaint.
My lord, I will just get back to that on that point, my lord. Yeah, that is my kindly.
Yes. Now, the charge which you read to us,
My
that
lord.
is at page, which was quoted, no?
Yes, my lord.
Charge is at page 24th, page 230. Charge is on 25th February at 11 hours. Verbally complaint. Oh, verbally complaint. Right. There was no charge sheet. There was no complaint to that. No complaint in writing. So the factum of being drunk was corroborated.
My lord.
Yes, proceed.
It says verbally complained.
Yes. No complaint in writing. Now, any seizure list was made? No seizure list was made. Now then how these betel nuts were disposed of? Was it in police malkhana or it was sold off?
Lord, I'll have to take instructions.
Back to them in the morning.
Uh-huh.
It was given back to them in the morning. They themselves have said.
Oh, it was given back.
Yes, to them it was given back.
That was not.
They have said. It was on the direction of the SP, it was given back to them in the next day morning.
So show, you will show us that
Yes,
page.
yes.
Yes, Mr. Chakraborty, proceed.
There in the original.
Yes, my lord. My lord, I was at
You are at page
234.
231.
234. No, 235, my lord. Bottom of the page. The relevant portion of the statement of Henry Samuel, PW2, is as under. Rajiv Biswas told me that ASI Sheshnath Singh was waiting for us. I, along with Rajiv Biswas, went to police station in a scooter. And from there, we went to the residential quarter of ASI Sheshnath Singh. Rajiv Biswas was holding one bottle of liquor with him. All of us, including ASI Sheshnath Singh, started consuming the liquor. ASI Sheshnath Singh called one constable and ordered for meals. Thereafter, we had consumed liquor and had a dinner together. I was directed by one constable to sit in Omni. The said constable hinted Shri Rajiv Biswas to be present in the godown.
Oh.
The above statement of Shri Henry Samuel has been corroborated by Rajiv Biswas. Relevant portion of statement of Rajiv Biswas is as under. At about 8 p.m., a telephone call was received from ASI Sheshnath Singh, directing me and Henry Samuel to meet with him at police station. We went to the police station office. From there, ASI Sheshnath Singh took us to his residential quarter. We opened the liquor bottle brought by me, and all of us, including ASI Sheshnath Singh, have consumed liquor. ASI Sheshnath Singh called one constable and ordered meals. ASI Sheshnath Singh directed one constable to seal the godown of Henry Samuel, and after sealing the godown, they went towards godown of Suresh and Anand. After some time, ASI Sheshnath Singh, Anand, driver of DSS, came back to the godown of Henry Samuel, and all of us had consumed liquor together. The above versions have been further corroborated by a statement of Shri Munir Ahmed, PW3. The relevant portion is reproduced as under. I asked ASI Sheshnath Singh or search warrant or order of any senior officer on this, he said there is an order for higher authority. Since ASI Sheshnath Singh was under the influence of liquor, therefore I thought better not to talk with him further. Thereafter, ASI Sheshnath Singh seized 8 bags of betel nut from the veranda of my house and loaded into truck. The inquiry officer in his report has held that from the statements of various PWs and the evidences brought on record, the misconduct of the delinquent officer in sealing godowns and seizure of betel nuts without observing legal procedure after consuming liquor has been proved. In this regard, the delinquent officer in his written reply dated 30th March 2010 did not take any plea in his support. In his defense brief dated 2nd August 2009, he did not refute the fact that he had sealed the godowns and seized betel nut without observing legal procedure. But on the charge of consumption of liquor, he has contended that on the basis of evidence of few of the interested persons, it can be said that I consume liquor. In this regard, it is stated that in order to establish that the person has consumed liquor, the prosecution must conduct medical examination. In this regard, no medical examination was done. The contention of delinquent officer that no medical examination was done to say that he had consumed liquor is devoid of any merit. The doctrine of proof beyond reasonable doubt is not applicable to disciplinary proceedings. Preponderance of probability is enough for establishing the misconduct in disciplinary proceedings. As held by inquiry officer in his report and rightly from the deposition of Shri Henry Samuel, it has been clearly established the delinquent officer had consumed liquor at his residence, which was brought by Shri Rajiv Biswas. The said deposition of Shri Henry Samuel was also corroborated by Shri Rajiv Biswas. Their depositions were further vindicated by the deposition of H.C. Pujan Prasad that before conducting search, seizure of betel nut bags and sealing the godowns, the delinquent had consumed liquor. Moreover, delinquent himself in a statement dated 20th February 2000 had admitted that he had consumed liquor. Therefore, it has been clearly established beyond doubt the delinquent officer had consumed liquor before performing duty, that too at odd hours, despite clear instructions of the superior officer. Such conduct of delinquent officer performing acts supposedly connected with his official duty in drunken condition is untenable in a disciplined police force. Finally, coming to misconduct of delinquent officer, that he had demanded illegal gratification from the traders, it would be appropriate to reproduce the relevant portions of the statements of the following PWs, which are as under. Shri Robson: I, along with my family members, were sleeping in our house on 26 February 2000 at about 2 a.m. in the night. On knocking the door by someone, my sister Vasanti had opened the door, and after seeing the presence of police, she called me. I went out and seen that ASI Sheshnath Singh and 4 to 5 police personnel were on uniform and the driver was on civil dress. Suddenly, ASI Sheshnath Singh has demanded rupees 50,000 from me. He also threatened and asked me, "Bahut paisa ho gaya hai kya?" On seeing the police in uniform and after the demand of rupees 50,000, I scared. I told ASI Sheshnath Singh that I could not fulfill the demand of money as my owner, Mr. Suresh, went to Teresa. Thereafter, police personnel took away 3 bags, small and 3 bags big, containing betel nuts without giving any receipt, and also they sealed the godown. Then Munir Ahmed, Shri Munir Ahmed, PW3, on the night of 26 February 2000, at about 2:30 a.m., I heard knocking the door. On this, I opened the door and saw that ASI Sheshnath Singh was standing out of my house along with 4 to 5 police personnel with 1 Omni and 1 truck. They were searching around my house. On inquiry, ASI Sheshnath Singh said that give money or otherwise betel nuts would be seized. Answering to a question during examination in chief about the amount of money demanded by ASI Sheshnath Singh from him, Shri Munir Ahmed has Munir Ahmed had deposed that ASI Sheshnath Singh had demanded rupees 20,000 from him. The delinquent officer in his written reply dated 30th March 2010 did not take any plea in his support. However, in his defense brief dated 2nd August 2009, he contended as under. The prosecution relied upon the deposition of Shri Robson but failed to consider the deposition of Shri Robson at the time of his examination. Shri Robson said that he does not remember the incident. Moreover, he did not say any amount alleged to have been demanded by me in a statement. So far as evidence of Shri Munir Ahmed is concerned, the same is not reliable because he's a government
Robson
servant.
is the other businessman.
Yes.
Robson is the first one, Munir is the second one.
Yes, ma'am. So far as the evidence of Shri Munir Ahmed is concerned, same is not reliable because he's the government servant and he cannot carry out any business. Even Shri Sanjay Singh IPS has confirmed the fact that he did not receive any money from the persons. The contention of the delinquent officer that prosecution relied upon statement of Sri Robson, PW1, but failed to consider his deposition made during cross-examination in which Sri Robson said that he did not remember the incident is misleading. As the fact on record is that Sri Robson never said that he did not remember the incident. He was only confused about the number of betel nut bags seized by the delinquent officer due to passage of time between the incident and recording of his statement. The contention of the delinquent officer that statement made by Sri Munir Ahmed cannot be relied upon as he is a government servant is also devoid of any merit. There is no reason for not relying upon the deposition made by Sri Munir Ahmed just because he is a government servant. As far as contention of delinquent officer that Sri Munir Ahmed being a government servant cannot be expected to run any business, such contention is devoid of any merit, being irrelevant to the misconduct of the delinquent officer. After contention of the delinquent officer mentioned above that even Sri Sanjay Singh IPS had admitted the delinquent did not receive any money from the persons is devoid of any merit, as the charge against the delinquent was not that he had received money, but that he had demanded illegal gratification, and on refusal he sealed the godowns and seized the betel nuts without observing legal procedure. The ulterior motive of the delinquent in sealing the godowns and seizing the bags containing betel nuts was to obtain illegal gratification, which has been proved by the statement deposed by Sri Robson, PW1, and corroborated by Sri Munir Ahmed, PW3. In his defense brief dated 2nd August 2009, the delinquent officer has further contended that the Honorable Court had directed to conduct a fresh inquiry against him, but the authorities relied upon the statements of witnesses procured in the year 2000. Such contention of the delinquent officer is also misleading, as the fact on record is that fresh statements had been recorded during the fresh inquiry in 2006. The inquiry officer in his report has rightly held that all the prosecution witnesses except 3 have been examined in the fresh inquiry and due opportunity have been given to the delinquent officer for cross-examination. I have carefully perused the written reply submitted by the charged officer on 30th March 2010 on the inquiry report submitted by the inquiry officer. In his written reply, he has simply contended that the entire act done by him during his tenure of posting was done in good faith, and the same might amount to procedural lapse and pleaded for leniency. The delinquent officer was also given an opportunity for personal hearing and was heard by the undersigned on 23rd April 2010 in orderly room. He did not add anything new to his written submissions and only reiterated the pleas he had listed in the written reply. His contention that he acted in good faith is not tenable. Despite clear instructions of Superintendent of Police, he acted in a manner unbecoming of a member of a disciplined police force with an ulterior motive to extort money from businessmen. He sealed the godowns and seized the bags containing the betel nuts, which is when his demand for illegal gratification was turned down by them. Such an act of the delinquent officer cannot be termed as a procedural lapse as contended by him. I do not find any denial of natural justice to him during the departmental inquiry. The delinquent himself also did not complain about any denial of natural justice. I have dispassionately examined the evidence on record adduced during the departmental inquiry, and I agree with the findings submitted by the inquiry officer. The charges of misconduct framed against the delinquent officer ASI Sheshnath Singh under suspension are grave in doubt and have been conclusively proved beyond any doubt. The conduct of delinquent is totally unbecoming as a member of a disciplined police force and needs to be dealt with with an iron hand. Otherwise, it would be detrimental to give a wrong signal to the other members of the entire police force. Therefore, then, my lord, this punishment is meted out. Now, my lord has already seen, my lord, the order of the disciplinary authority. My lord, the inquiry officer's report, my lord, is also very detailed, my lord, which your lordship will also find.
Chakravarti, there was an admission on his part. You said he begged for pardon. But this betel nut, this recovery, this was done without any preparation of Caesar list and everything. But was it returned, as being said by Miss Nag? That was returned.
It was returned to them in the next day.
Have you brought the manual?
Now, how can we Caesar report without Caesar list?
So that suggests that he took away those bags. When that return is admitted, it is he took away those bags.
It was seized, your lordship. He said it was seized. then as per the direction of the higher authority, it was released to them, returned to them, and they received it also.
Then that misconduct stands proved.
No, I'm. Your Lordship, taking away that particular material and then releasing that material, that is not the article of charge. Article of charge.
Yes, bribe.
Article of charge is bribe, which I will prove from their own statement. It has not been proved.
Money was not taken.
No, even Sanjay Singh has said, the SP has said that it has not been, it is.
No, money was not taken.
But demand for.
Demand for.
Why you
Have been done to.
Just a minute.
Why-
These are not a case of great. No, I just.
Such a discrepancy in the evidence, Your Lordship will find it out that particular demand is nowhere there.
Disciplinary authority, I read the very line in the disciplinary authority has categorically stated that this is not a case of illegal. Disciplinary authority has
If I'm
stated.
able to show,
My lord.
if I'm able to show that what disciplinary authority has said is contrary to the evidence, then I have a right to place it before the appellate authority so that he can.
So there's false implication against you.
Yes, Your Lordship, I can show it from the evidence
Why false implication against you?
because I have not listened to the direction of the SP.
Why you not listen?
Because illegal trade was going on and I wanted that he should mention it to me that don't go for it in writing. He refused. So tomorrow, when the persons who have given a complaint to me, they will realize that even after giving the complaint, he has done nothing.
There was no complaint. It's a verbal complaint.
Your Lordship, generally, Your Lordship, the complaint, people come to give the complaint, they don't give the complaint in writing.
Who are your
They
family members?
and give the complaint.
Who are your family members? Ascertain that and tell us tomorrow. Pathad, we will share it tomorrow.
So ASA, why? There is a police station.
Why will a person?
Why a personal complaint will be lodged before ASA?
Your Lordship, he was I think Your Lordship, he was the SHO of that police station at that.
He was
point.
the SHO.
So the complaint was lodged. And moreover, Your Lordship, the persons who gave the complaint,
Who is the Rajiv বিশ্বাস? Who is Rajiv বিশ্বাস?
he is also one of the traders.
Traders.
Trader, all trader.
And he brought the liquor.
Yes, he got the liquor.
Yes, he says
I
so.
will show from that.
We have missed this issue. He has brought the liquor.
Your Lordship, the persons who have given the complaint against me, none of the persons have been examined.
No, there was no complaint.
It is there.
There was a verbal complaint.
No. The complaint against me. The complaint which was given against me, that I have demanded bribe and all those, that complaint.
That is not referred to in the charge sheet.
Page number 103, Your Lordship, part of the charge sheet. 103.
Yes.
Complaint received from SOR Traders, Malacca dated this. Complaint received from HSK Enterprise Trading dated this. Complaint received from Timothy dated this. None of these three persons were examined. None of them.
All right, come back tomorrow.
Yes.
Hardly learned advocates appearing for the respective parties. List the matter for further consideration. Or শোনো তো গাড়ি come back tomorrow. If you can make us concise.
I will do it, man. Yes, my lord, I will do that.
The punishment provision under the manual, which clause?
Yes, I will.
You know that? Already tell us. Tell us, we shall check.
Yes.
9.3, my lord.
9.3.
I think police manual is there,
Yes, yeah, we have.
my lord.
But after.
Half an hour for-
140.
In the canteen, my lord. Most of us eat in the canteen, my lord. Most.
Mentioning. Item number on.
Your Lordship, it's by mistake, Your Lordship. It is disposed of. By mistake, I have mentioned.
Item number 2, WPA 170.
Lordship, in this matter, I am for the read petitioner.
I am for the respondents.
Yesterday, I have submitted the affidavit in service. The copy has not been served to today. I have supplied a copy to madam. She's already, generally she appears on behalf of the respondents.
My lord, just I have gone through that when as representations are pending, my lord. And moreover, my lord, one civil suit is also pending before the civil court.
Not related to that matter.
No, my lord, to the extent that representations which are pending before the Deputy Commissioner North and Middle Andaman, that can be disposed of. Because more than that, cannot. It's a Maya Bandar case, my lord. I have to take instruction if it goes beyond that. To the extent that representations to be considered, I'm okay with that.
Lordship, in this matter, the petitioner, she was allotted land in the North and Middle Andamans and in the year 1966. Since that time, she is staying in the land. But her land, along with the other neighboring plot holders, it is not connected with any path since 1966. Time to time, they have given the representation to the government that to provide the path, at least to be connected to the road. Because at the time of emergency or medical emergency, they have to face a lot of problems. Lordship. Yes, Lordship. Now, Lordship, after that, in the year 2013, the neighboring plot holders, they have surrendered their own land to the government, stating that we are surrendering and kindly make a path on that land. And everybody has surrendered the land. After that, Lordship, in the year 2019, this land was given possession to the Gram Panchayat to construct the road. And accordingly, a fund of rupees 8 lakh was also given in the year 2019. And after the allocation of the fund, the construction of the path started, Lordship. On 2 occasions, when the path construction was going on, one of the plot holder, whose father earlier has surrendered the land, he has occupied his piece of land, which he has previously surrendered. And due to this position, Lordship, the path construction could not go ahead as per the program. After that, many correspondence has been made with the Deputy Commissioner. And after that, the Tehsildar of that area has passed an order stating that this is a surrendered land and nobody can occupy this land because after surrender, it has become a government land. After which, the party who was creating hindrance, he filed a civil suit in the Mayabandar court, which is pending for adjudication for the same land. Now, Lordship, this is the position. After which, the petitioner, he has given 3 representations to the Deputy Commissioner that in the same land, the northern part of the land is a government land and it is a government park. So till the pendency or the outcome of the civil suit from the northern side, which is a government park, government land, from that land access could be given till the outcome of the civil suit. And 3 representations have been given, Lordship. Yes, Lordship.
That's
Lordship, kindly come to page 45. 45, 46, 47. These 3 pages are my representation, Lordship. 42 was when the work was stopped. That time the representation was given to the Deputy Commissioner to start the work once again. Those representations are. Lordship, in the community land, the Apex Court has already clearly said that community land has to be used for that purpose only.
Page 40.
45, Lordship. It has been mentioned, Lordship, in my representation. That's why we are very hopeful.
When did Panchayat start commencing the work?
2019, Lordship. That papers I have enclosed,
We
Lordship.
will not give it. We should wait for dependency of this.
Because maybe some
That order, but
injunction maybe have there, I don't know about the civil suit.
Lordship, till that time, because this is a settlement path, government is using this path. Lordship,
They by each of twice considering representation.
Lordship,
They will keep it waiting for 5 years and then pass an order that we cannot do anything.
Lordship, civil suit is not pending on this land. It is pending on the land which is on the southern side. This path which we are asking now, it is on the northern side, Lordship. It has nothing to do with that.
Then why you are bringing in the civil suit?
Civil suit, because previously I have to state before this Lordship about the surrender of the land and what is the status of that. For that only I have mentioned about the civil suit, because the land which we have surrendered.
Surrendered land in which the road has to be constructed.
Lordship,
Upon that is the civil suit portion
Lordship, Lordship.
intervening.
Yes,
Yes, Lordship.
yes, Mira.
But the path which I am asking now is not the surrendered land. It is the northern side of the land which belongs to government.
So you want a shifting of the.
Not shifting of the till the outcome of the civil suit. The land which we have surrendered. Lordship, because already government land is there, government is using that land. But since we have not, since we don't have any path.
Try to understand
Lordship.
this pathway which was brought out for construction.
Lordship.
There must have been a demarcation pathway was carved out, Panchayat was handed over.
Lordship,
Comments the-
Lordship,
Now you want to say that they are not doing since a portion has been
Encroached.
Lordship,
objected to by this person.
Lordship, Lordship.
So now you want that in the interim now, the road should be through another way.
No, another way, there is already existing road. What we are asking from that existing road, give us access in a time bound manner.
That what is the problem?
Lordship, that is a
Or
government
implicate
path.
that person within here. You implicate that person here, let him satisfy that the civil suit will not be affecting the roadway which is set up on him.
Look, that is the order of the Tehsildar, Lordship. And
So
in which there is no specific order, Lordship, but it can come out through the representation which has been given. Kindly come to page 29, Lordship. This is a no objection certificate given by the Tehsildar Mayabandar for construction of the path. And page 30 is the allocation of the fund.
Construction of management from geographic research to physical research land. Now you want your representation.
Lordship, it will be very clear. I'll show the map, Lordship. Kindly come to page
To
44.
understand, the project has been suspended due to the civil suit.
Lordship,
So in the interim now, how can they pursue a different route?
no,
Can they build up a new project? And
path is already there, Lordship. They don't have to build it. Path is already existent. It is a settlement path that belongs to government.
Where do we come to know from that? That is your only.
Kindly come to page 44, Lordship.
That is your statement in the representation.
In page 44, this is a map which I have given to the court. Kindly see the northern side, Lordship. It is a government revenue land. And from this land only, I want access to my property, Lordship. And southern side is the portion.
You can still use that land. You want a construction of a road, sir.
Kacha road, Lordship, even Lordship,
You
that
are
road
not-
is,
I think you already a portion has been settled, Yarmark and has been dedicated for construction.
Lordship,
That it will be from here to here.
Lordship,
So within that space, there is one portion in respect of the civil suit is paid.
Lordship,
So when civil suit is pending, then they are saying that we will not complete the work. But
Lordship.
that is causing more hindrances.
Lordship,
Now you are saying that during interregnum, to
Right.
allow me to construct a road on.
not
the
construct a road, road is already there. We are just asking to use the road. Road is already there, Lordship, there is a settlement
Who is
path.
preventing you from using
It
that?
is a government path, Lordship, we cannot use.
The interregnum you use for moving that land.
Then a direction, at least on my representation, if they will pass some orders, something, that I can use it, Lordship. Already there is a path. I'm not asking for a construction of a new path, Lordship.
The representations are not clear, my lord, regarding the north side.
These are not the above mentioned.
It's not clear, my lord.
Kindly come to page 47, Lordship. 47 is the representation, last, Lordship. It's very clear. Request to provide motorable road from government land bearing survey number 18, 166, 163 and 41 situated at Duke Nagar village, ward number 1 under Swadesh Nagar, Gram Panchayat. With humble request, I would like to, Lordship.
So saying that which touches our significant part of the government and from which access can be provided to these affected families.
There is all,
Not access, it's access.
yes, yes, it was
Yes, yes.
there even by them, Lordship. Yes, it is access. Settlement path is already there, Lordship. So I'm not asking for construction. Till the outcome, we can use it. Only that much we are asking, Lordship. Because during time of any medical emergency and all, it becomes difficult for the residents to come to the main road, Lordship.
Which is the main road.
Main road is connected from the settlement path. And we want access from the settlement path.
How you are now having the access for.
Kacha road only. Kacha road is there, Lordship, from 1966. We are facing the same difficulty. Because Lordship could see on the last page.
My lord, they're saying that government land, but we have to see, my lord, whether that government land, somebody has encroached it or that is free from pathway, because who is stopping them? It's a government land, anybody can use it because the pathway, it's to access to 10 families, he is saying. Though,
He's already having their project has been sanctioned.
yes, my lord, and because of the civil suit, they could not proceed,
That by the civil suit.
my lord.
Now he says, civil suit, let it be pending. If you cannot continue with the project, it will be an access to the settlement road.
My lord.
I don't understand why he's not getting the access. What is the problem?
Yes.
Anyone is preventing you from taking
That
access?
would
Lordship,
to
we
see
are
whether
not
the
using-
government
If
land
we will start using it,
That's-
problem will come. But if there is an order
that
passed by
means-
the deputy
Right,
commissioner,
that order, sir.
Lordship, we have given the representation 3
No
times.
matter.
my lord, I have to take instruction regarding the survey number which he has mentioned. 4 survey numbers he has mentioned. If my lord sees 18, 166, 163 and 41, these are like, it's not connected with these, if my lord sees the survey numbers. page 41. I have to check it whether these somebody has encroached this survey numbers or not. Why he is not getting the access from this land if it is free from my lord.
Item number 3, WPA 179 of 1025.
My lord has asked me to take instruction, my lord, in this matter, why the 7 years delay has occurred, my lord, regarding the mutation process. My lord, in this matter, my lord, Tehsildar has duly issued the notices. However, none of the petitioners and none of the parties have appeared before the authority, my lord. And for that reason, my lord, this matter has been delayed for so long. Even the petitioner, the writ petitioner also did not approach before the authority for executing the mutation or to advance the mutation process.
Your Lordship, herein, the petitioner actually purchased the subject land through an e-auction. After purchasing the said land, the petitioner was issued sale certificate. Relying upon the sale certificate, he approached the respondent authority in order to get the subject land mutated in his favor.
Where is that?
Your Lordship, after
There's no such representations. That's what I'm submitting, my lord.
Representation is not with the petitioner.
Neither any of the parties, because I think three parties are there.
After the representation being submitted, the respondent authority issued a notice, Form J, that is notice to the interested persons for carrying out the process of mutation. It is a part of the mutation proceeding. And this Form J was issued by the respondent authority on 20 June 2018. After that, the petitioner had.
What is this nature of acquisition? What is
Nature of acquisition, auction, no, was purchased.
The
Property.
petitioner had purchased this land through e-auction from the State Bank of India.
since 2008?
The petitioner had approached the office of the
No,
respondent authority
no,
several
my lord.
times, Your Lordship.
No, I deny that.
Your Lordship, he had physically approached and he had verbally stated before,
No,
but
no.
there is no such representation after the one which was submitted for mutation.
My lord, notice.
The copy of the representation is not, because it's very old, Your
How
Lordship.
you people find this sort of applications?
Your Lordship,
Without knowing the top and bottom of it. You don't think fine that the court will question me that what did I do for 6 years?
Your Lordship,
You are alleging inaction on their part. You yourself is dormant.
Your Lordship, the respondent authority was.
Withdraw and file fresh, enclosing appropriate documents.
Your Lordship, the Form J was issued, Your Lordship, acknowledging my application.
So it's what explanation you have given from 28 to 25, what were you doing?
Your Lordship, the petitioner has mentioned in the writ petition that he had been approaching and. Your Lordship.
What? Where is the PD?
Your Lordship, para 8, Your Lordship.
Soon away as you are dismissed and leaving. You are a young advocate, you will not question yourself. The court may ask me that 2018 time what I was doing. This paragraph you see.
Your Lordship, para 8, Your Lordship. That the writ petitioner had approached the office of the respondent authority on several occasions, whereby he was given an assurance of speedy mutation. But despite all such efforts by the writ petitioner, the mutation proceeding is kept pending for almost 7 years.
Now kindly come to the affidavit question. You have not incorporated this as true to knowledge or true to information derived from record. Sir, you are a junior counsel, learn all these things.
Your Lordship.
Paragraph 8 is missing from your affirmed statements. Is it there? Please learn all these things. For that I can dismiss it with heavy cost. You're in a legal forum, you're before the apex court. This is not a police station that you give whatever it may be that it will be accepted. There has to be application of mind, there has to be drafting, there has to be questioning of the client, and then the last stage is to come. Paragraph 8, you are telling me, and paragraph 8 is not affirmed.
Lordship,
Paragraph 8 you have affirmed.
Your Lordship, that the contents of paragraphs 2, 5, and 7 to 18 of the foregoing petition are true to the best of the knowledge and belief.
Your knowledge. Whether they can act on the basis of this after 7 years, I don't know. This Form J which you have submitted, which they have issued. Yeah. Happened 7 years. They did not also take any.
Your Lordship, the person concerned, they have been approaching, and there was no reply. Sales certificate is there, Your Lordship.
I have reviewed it. Should be careful in future.
Should-
Action.
Number 4, WPA 188 of 2025.
I'm for the respondent.
Okay, sir.
Yes, my lord, non-encumbrance. Your lordship has,
What happened?
on the last occasion, your lordship has directed that report to be given. I have brought this report, my lord. It's not the original, but a copy of this. Yes, yes, just give. The second page, my lord, second page of the report. The handwritten, my lord. No.
My signature is not
It's his land only that he has gone to see that land, that he has measured the land, and it was found that it is excess to what is record as per the recorded land. His recorded land is, I think, 0.0579 hectares. Whereas it is found that she is in occupation of land measuring,
164.8 square meter.
no, my lord.
by 79 square meter, my lord.
It is, her recorded land is 0.0579 hectares, my lord.
It's on page 28.
And she was found in occupation of 690 square meters, which is excess to her recorded land. Which-
Of the recorded check exceeds the area mentioned in the
Record of rights. My lord, may kindly come to the record of rights, my lord.
By
Yes.
79 square meter, my lord.
0.0579 hectares. So, my lord, may kindly come to the report, my lord. 0.0579 hectares,
Occupy
690. It exceeds her recorded land.
so in respect of the.
No, first,
recorded.
no, my lord, first she has to demarcate that land, but we have to demarcate land. And thereafter, she has to relocate the boundary. And after it's the excess area is vacated by the writ petitioner, thereafter only we can issue the non-encumbrance. Your lordship may kindly come to the rules. Andaman Nicobar land revenue, land reform rules, my lord, second part. First part is regulation, second part, my lord. Until and unless she will vacate her excess area, we will not give her non-encumbrance certificate. My lord, the second part, 168, my lord. Rule 168. It's not the first part, it will be in the come in the second part, page 23.
One
168, my lord.
68.
168. Second part, my lord. First part is the regulation. Second part, page 23. My lord. May I read, my lord? Permission under subsection 9 of section 159 to a licensee to transfer 168, my lord.
No,
Page 23, my lord.
yes, page 168.
Regulation 168.
It opens up in determining there. Certain portion. Yes. 159.9.
That is the right to transfer his interest. 159, that will become in the first part, section. That regulation, 159. That is right to transfer. The first part, page 31.
One, yes.
Right to transfer, my lord.
What you say, it only as a regulation. What you say section?
Now rules, yes. Regulation 115.
Yes.
My lord, now come to again 168, my lord. Land being a house site shall not be granted unless the following conditions are satisfied. Thereafter, my lord, D, clause D. That is a relevant clause, clause D. the licensee should not have in his possession any area of land in excess of the area which was actually allotted to him. That is, he shall not be an encroacher. Permission to an encroacher shall be granted only after duly vacated. So, my lord, until and unless the property is demarcated and we have to vacate that whatever the excess possession she has in her occupation, thereafter only we can issue the non-encumbrance certificate.
Since of his application after the expiry of that initial period.
She must have, because
uh,
the second application, my lord.
She made any further application.
Yes,
after
yes,
expiry?
yes.
Why
She has made.
considering that you have said
Yes, my lord.
that is your.
The report of the Patwari.
That you have applied by this memo of 10th February.
My lord. My lord, the report, my lord.
The wedding shall make on the fresh inspection.
To demarcate the property and thereafter to remove her from the excess area.
From this,
And she has to vacate that excess area, thereafter we will issue. My lord.
That condition has to be in the presence of your officer.
Yes, we will demarcate, my lord.
Yes, you demarcate.
Yes.
And we
Let
can
there be
also
direction.
go to the spot,
Yes, of
demarcate
course.
him.
Of course.
If he is not in possession of the excess, then there is no.
There is no question. But we have measured that the field report. It says that she is in occupation of the excess area. Apart from her record. My lord, may kindly come to the report, my lord. The second page. Second page. Yes, yes. This is the communication. Correspondence and all. Second page, my lord. Third para. Field inspection revealed that a kacha house covering an area such and such square meter and a semi-RCC residential structure covering area such and such square meter standing upon the above mentioned survey number. Further, it is revealed while measuring the existing possession of the tenant on ground. It comes approximately 690 square meters, which is more than the recorded area of the tenant as per the record of rights. ROR means record of rights.
So tenants means.
She is the recorded tenant.
And that.
No. Actually, we are all recorded tenant. We have said that.
Recorded tenant, he reported along with 5 others.
Yes. It's a joint recorded tenant.
Now, in the event that 5 other tenants are occupying that, what he will do? What should we do? Suppose the position is of not of.
Yes. That she has to apply for her share, then she has to confine to her share only, not 590 square meter hectares. She has applied for 0590 hectares, 0579 hectares, entire land.
Once. Her portion.
Her portion, but how much area? She has not described that.
There is not divided share.
Yes, my lord, but we have to see where is her share, my lord. The demarcation is very much required. And the area we have to carve from the 0.579 hectares.
Then where were the steps? Why were not taken? Why get first certificate?
First certificate, my lord.
He pressurized the certificate.
That I cannot see.
Because your commissioner are showing so many different regulations. He did not realize that why he issued the birth certificate. We knew that this would create a right. This madam.
what my letter friend has just not read here, that is, he shall not be an encroacher. And from the report, it is not said, I'm an encroacher. I'm not an encroacher of any excess land, madam. They have said I am possession of 690 square meter, not the government land. Because there is no government land. Because, my lord,
You are saying that.
my lord, kindly see once the page 22, my lord. Page 22, sir.
Page 22,
Madam,
my
it
son,
could be not conducted. What means I can record your submission, her submission, I can delegate for inspection and appropriate.
that can be done. That can be done. Because there is no boundary. There is no boundary. What they are saying have encroached the land. There is no boundary. All recorded tenants, joint recorded tenants, all are relatives.
On instruction, I'm
All
submitting, my
related.
lord, the Patwari,
Kindly see the sketch map, my lord.
like
It
the
is very
writ
clear.
petitioner was
6 by 1.
creating a nuisance
all
like
the-
anything at the
all
time
the-
of inspection. She has created a nuisance. This writ petition on instruction I'm submitting, my lord. So until and unless there is a direction for demarcation, my lord, we are not able to demarcate how much portion he is in, she is
By giving a notice, my lord.
in
They
excess
cannot
and
come directly to the,
yes,
premises, my
the
lord.
due notices will come.
Access to all.
All the interest, all the legal heirs.
All the legal heirs.
Adjacent plot owners are the legal heirs only,
All interested persons.
all interested persons.
Putting the co-tenants which are.
Yes, yes, my lord, the adjacent co-tenants, yes, my lord.
There is no dispute, my lord, with regard to co-tenants also, because all are brothers and sisters. After subdivision, this portion has come to the petitioner, my lord.
Item number 5, WPA 189 of 2025.
Petition not there.
Senior appears for the
Time
petition.
lady, how much time left?
My senior appears for the petition in this case.
Yes, very good, sir.
It's on his legs before the court number.
Well,
Pass on.
not today, my lord. कल करेंगे.
Other respondents are there, solution for that one, whatever.
My lord, we spoke to them, my lord. They are trying to work out something departmentally, my lord, to understand, because I appreciate, my lord, the difficulty. Now, my lord, Pollution Control Board and Revenue, and I think the Chief Secretary is also looking into the matter. So, my lord, may either, my lord, keep it for next circuit, my lord. The meantime, we'll. No, pollution, that is difficulties, my lord. Certain norms are there. Pollution Control Board, my lord, based on the.
Norms and already they need to follow, ask your senior.
My,
Okay, item number 6, WPA 198 of 135.
Mr. Chakravarti, Mr. Kumar was there, now to make it pass over, ask your senior to come there. To come to the-
my lord, my.
Item number 6. Yes, Mr.
I'm there for.
You're for the petition.
One respondent being respondent number 4.
I will be appearing on behalf of respondent 1, 2, and 3.
4 is having office at Maya Bandar. It has been dispatched, my lord. Normally, Mrs. Nag appears in one of my matters, Mrs. Nag appears for BSNL. I
Yes,
can
yes, where is that?
it's in the list.
Where is Miss Nag?
I'll just.
To that termination or
Termination order. Under the.
3, 4, 5,
Yes, yes.
but then what do we do?
No, I have great points of interim protection. I have sought for dispensation of notice so far as. Boris.
What interim protection?
My property is being invaded without due process of law. They want to take my property, they want to dispossess me from the property, my recorded property.
Yes, sir.
Most BSNL. To raise some.
How to take instructions and come, but it is to be served.
Dispatched it, it will take time, my own. That's over 2-3 days we are left with.
Want to take it. And it's not that matter of. Family is not there.
Yes, yes, yes.
Subject to what you say. Numbers on the ground of natural justice. So this can be done, that he can, as you have not essayed that order subsequently also and allowed him to continue temporarily. This court may observe that such temporary continuance will be delivered on the husband. And in the event he is on the, then you would be at liberty to take appropriate decision. Yes, but it's with law. But we shall, but this court will direct that she will be continued temporarily.
Yes.
Once she gets that acquittal, you will consider for confirmation, and if she is convicted, you will take steps in that.
Your Lordship, this is the best one, Your Lordship.
Sure. Which is your
No,
matter?
that is.
Any other respondent is there?
No.
Item number 20.
The respondent are there, we cannot.
Only BSNL.
BSNL is.
She is the employee of BSNL. Even I spoke to my client, they also, I have told that this may be the order. This actually, Your Lordship expressed Your Lordship's mind on the last occasion. So I spoke to them. They said our consent should not be recorded, even we want that she should continue.
20. Item number 20. Item number 20, WPA 18 of 2024.
125.
Answer the response.
But very small issue is involved in this case. The petitioner is the purchased owner of land bearing survey number 2629/1 and 2629/2. Which he has purchased during the year 2012 and 2013 respectively. Both survey number 2629/1, 2629/2.
You have purchased these two plots.
Two plots, 200 square meter each, out of total area of six,
No, in the two plots, there is a total of 400 square meters. 200 each you have purchased.
200 each I have purchased.
Then what happened?
And the rest,
Where have you stated that in your petition?
para 5 and
Why
6.
you have not implicated the Zubaida Adam? She is standing in the way.
Lordship, what happened, she has earlier also on several occasions has made an application before the revenue authority for demarcation of the land. And on all such occasion, demarcation was conducted in presence of the petitioner. And the land of the petitioner was not interfered with. On 24th of February 2025, surprisingly, one surveyor came when the petitioner was on duty. One surveyor, namely Mohammed Rafiq, he entered into the plot of the petitioner, and on his instruction, that Zubaida has put up pillar in the land of the petitioner. When the petitioner came to know about the same, immediately on the next day, he made a complaint before the revenue authority stating the facts. That complaint is in page number 17.
Very important.
Followed by another complaint on 27th of February, that is on page number 19. And in this complaint, the petitioner has narrated the entire factum and he has categorically stated that categorically stated about the factum of the illegal act committed by that Mohammed Rafiq in connivance of Zubaida, and he has requested the deputy commissioner to assign some other survey to conduct re-demarcation. Thereafter, on 26th of February 2025, he has made an application through online for demarcation of his land. On the basis of that application, a notice was issued on 7th of March 2025. Notice for demarcation.
Page 13, last page.
And if your lordship sees in copy to column, in
Mohammed
fourth
Rafiq.
number, the same
No, Mohammed Rafiq. Surveyor,
Mohammed Rafiq,
the same surveyor was
same
appointed.
surveyor was appointed.
Yes.
And
She wants that to change the surveyor.
And on lordship, on 25th of March, the surveyor went to demarcation, but he has started making lame excuses that that Zubaida is not present, and later subsequently he has taken a signature of the petitioner and the adjustment plot on the in a document wherein it was written that since Zubaida is not present, so he's deferred and he'll be not conducting the demarcation on that. So the petitioner prays that before this honorable court to direct the respondent to assign some other surveyor or to assign a surveyor from a private authority, and the petitioner is ready to bear the cost for that.
I don't know whether we have got 4 other surveyors are also there. So he is the sole one.
No, there are
Other surveyors are there, my lord. Let me take instruction, my lord, whether any other surveyor can be appointed in this case, because the same surveyor.
Let it be tomorrow. Otherwise, on the basis of that demarcation, she will.
She says
Yeah.
that is possible. You should have ought to have impeded Zubaida, then we could have disclosed the person.
Yes.
Anyway, madam, please take
Ma'am,
instruction. If you
other
find
surveyor can be
another
appointed.
person,
Ma'am.
with the upon notice to
All the.
Okay.
Okay.
Item number 8. WPA 200 of 2025.
Record rent of the land. At page number 30. Page number 1, the record of holding register, the name of the petitioner.
Yes, the adjacent plot holder is raising construction. And he covered the entire drainage, public drainage. So I made a complaint to the secretary and the building inspector, municipal council to take action against the adjacent plot holder. But no action was taken. And into the photograph also, page number 18.
7 March representation, it's a bit early for.
Let them take, is going on full swing.
My lord, may direct my lord and representation.
Process is going on.
My lord.
इतना चल गया हो जाएगा तो ही क्या तब विलायत बन जाएगा
Yes, sir. Service, I send it by post, my lord. It is here. The service.
I am appearing, my lord, for the municipal council. Private respondent, I am not. Private respondent.
Track report. File the track report. No, Dear to tomorrow.
Get to guys, कुछ भी हो सकता है assume मत किया करो, पूछ लेना, ठीक है?
Man.
Item 9, there will be a 201 of 2025. Sanjay Roy. Sangeet Roy.
Yes, so everybody. Adjournment was adjournment was made. Item number 6. You are hearing 6.
I am in 5 man.
6 is different, where both.
5, my lord, that was item 5.
Oh, 5.
My lord has asked them to take instruction, my lord, this is not different.
My lord, we may either my lord may permit us to file affidavit.
Yes.
Either my lord may permit us to file affidavit. Otherwise, my lord, on this aspect, I appreciate my lord what is. There is definitely a problem, my lord. Administration is also, my lord, aware of that. Because, my lord, the difficulty is, my lord, conversion is not happening. Now,
10 years.
Last 10 years, that is correct. Now, the problem is that, for example, my lord, if the a particular plot is there, now the plot is in an area which is which is required to be converted to carry out a particular business or activity. At the same time, conversion is not happening. So the difficulty is, my lord, unless provisional NOC is given, they will not be able to carry out the business activity. And the difficulty which the Pollution Control Board has is to give the NOC. Pollution Control Board has to ascertain what is the use, or has to ascertain the nature of activity involved. So difficulty is, my lord, today for the Pollution Control Board, because the consequences from the environmental point of view will be different for commercial, non-commercial, agricultural. Everything has a different environmental impact. So the difficulty is, my lord, that is the difficulty of the Pollution Control Board. But at the same time, in the larger scheme of things, Pollution Control Board is also under the administration. So, my lord, I discussed this, my lord, this matter specifically with the administration at the highest levels. So they appreciate, my lord, this problem. So, my lord, they will work something out. But my lord, some time will be required. If my lord may either adjourn it, my lord, saying, or otherwise, my lord may, as your lordship deems
Let
it.
me say something. We can take-
Yes, my lord, that will
Otherwise
be.
it will not be done.
Yes, my lord, that will be very helpful, my lord. for the-
Fine, just
My lord, I have applied before the pollution control to get consent for the purpose of starting a clinic in Port Blair. And in terms of the application form which they are issuing, which is online, my lord, it clearly says the land usage, page number 10, para 18. That document also I have handed over, my lord, their application form. Page number 10, para 18 of my pleadings, my lord. This is the only issue, my lord, because of which it has been stalled, my lord. Paragraph number 18, my lord.
yes.
It says, my lord, clause 35A of the application form for apply of consent to establish issued by the respondent number 1 under the caption land usage classification of the site. These are the options given, my lord. And commercial use zone is one of the options. If it is commercial use zone, it can be done. My land comes within commercial use zone because town planner has given me the certificate, my lord, on 13th of January, page 35.
Falls under commercial land use.
So, my lord, I fulfill the requirement in terms of their form, but now they are negating the claim by saying that
Form of pollution control.
pollution control, my lord. This is their form. I have handed over the copy of that form also, my lord. Yes.
Then they are denying it on what saying what?
They are saying that commercial certificate is required, my lord. That page 36.
Then commercial
Conversion certificate. And my lord, I have gone through all the laws, my lord, which governs the affair. The water prevention of control pollution, then air prevention. No such requirement is there. And rather, my lord, this clinical act says, my lord, it ought to be given to me within 10 days, my lord, from the date when I apply under section 15. Under section 15. Yes, my lord. Under section 15, it says, when I apply to the for the purpose of running a clinic, the authority, that is the deputy commissioner, is the authority, my lord. He has to give me license to run it for a period of 2 years, provisionally, my lord. The statute says. Now, my lord, this problem which has been faced by the islander, that is under Clinic Establishment Registration and Regulation Act 2010. I am sorry, my lord. This is there, my lord. A chapter deals with that, my lord. I am sorry, my lord. I am marked somewhere.
By the pollution control.
No, this is given by the deputy commissioner. No, my lord, deputy commissioner is ready to give. Deputy commissioner, in a meeting I have shown to my lord, at page 44, deputy commissioner says to them, you issue it. Subsequently, it can be taken. This is the minutes of the meeting, my lord.
Minutes of the meeting is with whom?
With all the stakeholder, even the, if they are also there, my lord, I have seen somewhere there.
Then what it says?
It says, my lord, page 44, second paragraph, last, agenda 2, second paragraph. The reason cited for the non-issuance of NOC authorization from the Pollution Control Committee was the non-commercial nature of land. It was highlighted that even though applications has been submitted for land use change, their applications have been pending and therefore unable to get the required NOC authorization from the Pollution Control Committee, as copy of land document is mandatory required for that. Further, it is also informed to the committee that as per the norm, the authority shall not undertake any inquiry prior to the grant of provisional registration and shall, within a period of 10 days from the date of receipt of such application, grant to the applicant a certificate of provisional registration containing particulars and information. This is Act Section 15 of the Clinical Act, my lord. Thereafter, it says, keeping in the view of above situations.
Provisional registration has to be.
At least that administration. Yes, administration is ready to give unless and until they give pollution clearance, the administration is unable to give. That's why it's last paragraph it says, keeping in the view of above situation, the committee was of the view that to ensure better healthcare facilities to the community and for proper regulation and compliance of Clinical Establishment Act, the district registering authority may ask the Andaman Nicobar Pollution Control to provide a one-time window for giving condition NOC
Agenda 2.
for 1 year to the private clinical establishment who are not able to get the same as the process for the land use change has been pending.
No, total land use change, where is it pending? They are saying that it is.
No, it is
falls
pending.
under commercial-
No, my lord, that is
No, no.
not required. If at all, because they are asking that it ought to be commercial land. In that case, that conversion has to be made by the deputy commissioner. And from last 10 years, they are not carrying any conversion of land.
Conversion use zone, who can set up. the-
Yes, it is not
Commercial use zone.
that, but they are asking, my lord. But they are asking you give me, because page 36, my lord, may kindly see.
They are asking for land.
Conversion certificate, that is to be issued by the deputy commissioner, by the,
But your contention is no such conversion.
not required, my lord. As per their application form, I will go by their application form. It is not required.
That we are disputing, my lord, that I have got
You-
documents, my
It is
lord.
your application, I have given the.
No, I am carrying, my lord, perhaps the.
Yes, the
No,
application
this
is
clearly
clear.
it is their land commercial conversion certificate is required to be uploaded. I have got those documents, my lord. For that I'll have to file an affidavit, but I am only submitting, my lord. Otherwise, I'll file an affidavit, my lord.
You are deporting service. The the urgency is appreciated.
Yes.
Yes, my lord.
And provides the. So.
Yes.
The right of that you consider the representation and take a decision.
Yes, my lord, that can be done.
The applications.
No. Yes, my lord, my lord. That can be done, my lord. Yes, my
Yes,
lord.
that can be.
In fact, this writ can be also taken into account as part of the representation. That will, no, because it is
No,
formulated.
That application which is there, that is to be considered, not.
Take a decision and communicate to him. That
Yes.
This, unless you communicate it to him.
No, we will do that, my lord. Then let it be disposed of, my lord. The writ petition also can be disposed of. And my lord, this writ also may be treated as a
What is the
representation.
application? I have.
No, but the legal points will not be there in the application. No, it will be it will be easier for everyone, my lord, if it is. उसमें आप लोग क्या writ dispose of कर देंगे. I am
So
appealing.
according to the administration, this.
Page 44.
No, my lord, I have not filed my affidavit, but my lord, it can be, I appreciate what is falling from my lordship, my lord. Without entering into the merits, my lord, let it be, his submissions may be recorded, my lord.
This submission is also to be recorded.
No, let it be disposed of, my lord. As a representation, it can be disposed of, my lord.
Representation, that there is a performer and application.
Yes, the application will be taken. Same thing I'm also saying.
Anything here that this application has to be, how do you get the decision on it? They have issued this page 36.
My lord.
That no convert, that land commercial convert, therefore it is you have to provide. Unless you provide that, they will not.
Yes. That is the problem.
Yes.
Then Mr. Kumar, there has to be a finding, na? that
My
there
lord,
is
page
some-
34, my lord will find, they have issued this to some other clinic. Why this discrimination, my lord?
Then I'll file affidavit in that
This is
case.
my letter.
Then I'll have to file an
My
affidavit.
learned friend time and again says affidavit, my learned friend knows for.
No, I was trying to resolve, but
There is
problem
no
is what can
circuit.
be done.
So it will be linger on, that's.
I made a suggestion to dispose it.
That they by say, they will not consider unless this land commercial conversion. Then I have to decide. As you have submitted that there is no requirement for such.
Yes. As per the application form, it is not required.
I am trying to find a way out, my lord. What I am submitting is,
Yes.
I am submitting, my lord, because I discussed it with the authorities also, my lord. My lord, rather than going into the question of whether this land conversion certificate is required or not, my lord, what is important is, my lord, even if he gets a provisional certificate, my lord, for the time, his purpose will be solved. So what I am submitting is, my lord, there is a difficulty which he has mentioned in the writ petition, because assuming that conversion certificate is required, if the process of conversion itself is stalled, how will he get the certificate? It's not his fault that he doesn't get the certificate. So therefore, my lord, what I am submitting is, my lord, this can be a writ petition and application.
That, but your authority will say that I will not do it since that certificate is not.
No, my lord, they are trying, they will, this because if that certificate is not being issued, not for any fault of his, but because there is a policy decision not to do conversion, then the authorities in the larger interest have to find a solution, because eventually it's a clinic which is being set up. It will be for the benefit of the islanders. So my lord, in that case, my lord, they will issue a provisional certificate, or they will find some other solution, my lord, which has been which in fact the DC Deputy Commissioner has even suggested, as pointed out by Mr. Kumar. So what I am submitting, my lord, is that rather than going into the merits of whether document is then we'll have to file affidavit, my lord, because then my lord will have to decide the issue, my lord. So instead of that, my lord, this can be a
Asking for this land commercial conversion certificate.
Who is has the power to take design the water act to them?
Be silent about this compulsory
Yes.
requirement of conversion.
Yes.
And it is said conspirators and decision and immediate issue a provision of.
Yes, madam.
my lord. Yes, my lord.
Yes.
Please.
क्लिनिक खुलेगा तो क्या होगा? सब्जी भी फल में जाएगा क्या? भला तो नहीं करेगा।